Let's there was a recommendation for upgradation of the Hajipur Nagar Parishad to Nagar Nigam, but the recommendation was turned down, and then a fresh recommendation was sent that it should be some area has to be included in the old jurisdiction of the. Therefore, the grievance is that it should be not upgraded as a Nagar Nigam because it has achieved the required population of more.
File objection.
Lords, for that purposes, Lords, there is no provision of objection. The objection is always against the
no provision in the statute by which you can claim upgradation. At best, you have an entitlement to file objection under the statute. So when the statute does not confer any such right in the petitioner, there is a question.
Therefore, I have come that if there was a recommendation and the report was also there for its upgradation that the population, urban population has exceeded more than 2 lakhs.
So is any action beyond jurisdiction?
Plus, what they have done that the earlier proposal was returned back to the municipality for a fresh recommendation, and then certain area was not.
Tomorrow within first 5 cases.
Let's say, while constituting a Nagar Panchayat, Saraiya Nagar Panchayat, the petitioner's village has also been included therein, though it is, it is a village where more than 50% are there agricultural laborers.
Tomorrow, within first 5 cases. Yes. Tomorrow, in first 5 cases.
5 CWC number 20463 of 21 Mr. Ashok Kumar.
My lords, I am the chairman of the Nagar Parishad, my lords, and I have been removed under section 25(5) of the Municipal Act, my lords. Now that is under challenge before your lordships on the grounds that it cannot be. I mean, the procedures are laid down under 25(5) and that has not been followed. I have not been heard, nothing has been done, and a straight order has come out that I be removed. Now that is not permitted, my lords. There are judgments to that effect.
When was the order passed?
Well, this order was
just a minute.
About 10 days back.
Life of the body still survives.
Sorry, my lord?
Whether the life still survives of
yes,
the body?
Yes, the body is in existence, my lords. It survives. It's only I who have been removed, my lords, under section 25(5). So, my lords,
all right, Tuesday, opening.
Reopening, my lords?
After opening.
Very well, my lords. Obliged.
CWC number 20702 of 21, Mr. Jayaprakash Verma.
Thursday, within first 5 cases.
Number 1 under the heading for the division. Followed to Mandala versus Delhi of India Nagar for the petition to take up to Master to Kalkutta for the state result.
My lord, in this case, I am for the petitioner. Mr. PN Sai has to argue this case. Any date may be fixed in first week, my lord. He has resigned from a state, he is engaged in some important cases, my lord.
This is less important.
Pleadings are complete, my lord.
थर्सडे को रख दिया जाए बिकॉज हिज थर्सडे को रख दिया जाए
After holidays,
After of
दे हैव गॉट ए स्टे ऑर्डर मिला
stay.
we are ready, my lord. Any date, my lord.
इट इज कंटिन्यूइंग सिंस 3/9/2015
This is of 2015.
my lord
That was due to filing of counter from CBI, my lord. They have filed in last month, my lord. Ji.
This has been listed under the heading to be mentioned,
my lord
My lord.
right?
your lordship had told that it shall be heard under the heading to be mentioned itself
Finally.
my lord
Tomorrow we can take up,
yes my lord
Well,
as requested on behalf of the petitioner, list this matter tomorrow.
Item 2, PWC number 25090 of AC, the director versus the Gujarat for the petition to regard the Mr. Punya.
May I please, my lord? This writ is against order passed by CAT in original application as also, my lord, dismissing the review application. Facts are very limited. 3-4 dates should be relevant, my lord.
Yes.
An advertisement was issued, my lord, for filling up 2 posts of research assistant, which was later on designated as technical assistant in RMRIS. In, my lord, on that advertisement was issued on 11/7/2009.
Yes.
Selection process was undertaken. The 2 persons were made an offer of appointment, 1 and 2. A respondent herein who filed OA, he was waitlisted 1. Out of 2,
When was the merit list prepared?
merit list was, my lord, prepared on 3/1/13. Panel was prepared on 3/1/13.
Yes.
Offer was extended to the 2 persons, selected persons, out of which number 2 joined. Number 1, whose name is Rahul Priyadarshi, he didn't join and instead requested for extension,
Yes.
which was allowed.
Yes.
Finally, my lord, he was on 28/7/14, he was asked to join, failing which the offer shall stand cancelled. Still he didn't join. Validity of panel is only 1 year. As per notification of Government of India, Ministry of Personnel and Administrative Reforms,
Yes.
and that was notified on 23/10/2014. That panel has lapsed.
Where?
Annexure 9, my lord, 23/10/2014.
Yes.
In 2016, father of respondent, private respondent, he made an application under RTI seeking information in regard to filling up of the vacancy. That information was furnished on 4/7/2016, which is Annexure 4, clearly mentioning that he was a waitlisted candidate, the panel has expired, and the panel has been cancelled. Then he filed an OA, which first OA was permitted to be withdrawn with liberty to file a properly drafted petition, which petition was filed, and that OA has been allowed, directing for his appointment. Now, this is the case, my lord, and this is what is under challenge.
It is his case that the panel was never notified, and therefore he did not have any information. As to when was the panel prepared.
Yes. His case is that his case is that he was not aware that the post has remained unfilled.
No.
And as he was waitlist one candidate, since one post was not filled up, therefore as he was number one in waiting list, therefore he had a right to be considered. That is his case, my lord. And now even the system, even the procedure of appointment has undergone change. RMRIS Patna is not an authority to make appointment. All appointment have become centralized. RMRIS is only a branch of the main organization. So now the appointment has to be made by the parent body. And a central.
Where is your panel?
Yes, that panel is, I will show it. Page 44, Page 39 would be, my lord. 39.
Page 39, answer 5.
Page 39.
No, page 39 is not the panel.
This was final result, my lord. Kindly see. An interview was arranged for personal discussion for selection of suitable candidate for appointment.
That is at page
39. 39. Annexure 5.
Yes.
May I place that? An interview was arranged for personal discussion for selection of suitable candidates for appointment as research assistant, technical assistant, research. Amongst the candidates selected in written screening exam held on 18th August, on 3rd January at RMRIS, the interview board,
No, please, Mr. Shahi, please come to page 37.
37. Yes, my lord.
The last line. List of merit
Merit
list
is enclosed as annexure 1.
Where is this?
Next page, my lord.
No, next page is in continuation of
Yes.
the previous page. But this refers to a merit list. Annexure 6, where is the merit list?
Annexure 6, my lord,
Page
is
40.
to Rahul Priyadarshi, who was number 1 candidate. He was given notice that if he...
No, probably there is some difference in page number. Please come to annexure 6.
Which is page 40.
40.
Yes.
This is
This
merit
is,
list.
this is an offer, this is a notice to my lord.
Therefore, we are saying that there is some difference between your pagination and our pagination.
Oh, I see.
Annexure 6 is, please come to the next page, next to what you are reading.
I was reading, my lord, annexure 5.
Communication to Rahul Priyadarshi.
Yes.
So next to that.
Next page is, my lord,
This is the final result.
no, this was final letter given to Rahul Priyadarshi that if he fails to join on or before 14/8, then his offer will stand automatically cancelled with effect from that date. Annexure 6 is an offer of amendment.
Please come to page 39.
35.
39.
39. Yes. This reads, my lord,
That is the merit list.
yes,
Final result.
yes, final result. That is the merit list.
This was prepared on 3/1/2013.
Yes, my lord, 3/1/2013. And offer was made to Rahul Priyadarshi. He, my lord, sought extension. Then annexure 7, page 41.
Where is that decision of the central government which prescribes
That is
life of the panel?
That is annexure 8 on page. It would be, if it matches, my lord, page would be 44. Or rather, it starts on page
42.
42. Relevant, my lord, will find page 44, Roman clause 12. The panel recommended by the committee will remain valid for 1 year. If no selection is made from the panel within a period of 1 year, a fresh committee shall be constituted to prepare a fresh panel. Such a committee may also consider names of persons recommended in the earlier panel. In the present case, my lord, thereafter no fresh exercise has been undertaken, and in the meantime, the process has also changed. Now, all selection and appointments are to be made by the parent body.
And let us see the order of the tribunal.
Yes. That would be, my lord, annexure 1. 1 is the main order and we went in review, that is annexure 2. Kindly come to, my lord, finding starts on page 28. We have heard, second paragraph, we have heard counsel for both parties. The main plank of argument of learned counsel for respondent number 3 is that since the life of panel was for 1 year, applicant cannot get appointment after lapse of said currency of 1 year. Less spoken about conduct of recruitment authority is better. Respondent never published any result either in newspaper or in website or even in notice board of the office. So once panel is not published, question of running of limitation of 1 year from the date of publication of the result or panel does not arise. Learned counsel for respondent fairly admitted that the panel of selection committee sat on 3-1-13 and selected 2 candidates of merit list and kept 2 candidates in waiting list. Learned counsel for official respondent number 3, so and so has made available in course of argument copy of decision of selection committee which is taken on record and marked annexure D on behalf of respondent. The said selection committee proceeding discloses that Rahul Pridarshi was at serial number 1, Tathakat Gupta was at serial number 2, and present applicant was kept under waiting list at serial number 1, and one Dinesh Kumar Sahu was at serial number 2 in the waiting list. This fact was also never disclosed in written statement that as per decision of selection committee, applicant was serial number 1 in waiting list. If selection was made on 3-1-13, we fail to understand how appointment letter was issued to Rahul Pridarshi, the person at serial number 1 on only on 2-8-13 annexure A2 series after lapse of 7 months. Even the offer of appointment dated 2-8-13 discloses that on basis of interview held on 3-1-13 he has been selected for post of research assistant and has been directed to join latest by 19-8-13. There is no mention of publication of result. Another peculiar aspect of functioning of authorities comes to light from annexure 1 series. It is really strange how Tathagat Gupta, who is at serial number 2 in merit list, joined on 11-7-13 and letter of appointment was issued to Rahul Pridarshi, who is serial number 1 in merit list, on 2-8-13. Had the panel published at any point of time, certainly it would have expired on completion of 1 year. The recruitment guideline dated filed by respondent discloses that panel recommended by committee will remain valid for 1 year. Clause 5(4) clearly envisages the panel recommended by committee will be valid for 1 year, and if no selection is made from the panel within a period of 1 year, a fresh committee shall be constituted. So after recommendation by committee which was done on 3-1-13, it would have been followed by appointment. Select list should have been published, which the department did not do for obvious reasons best known to them. So the million-dollar question is from which date the panel shall run when there was no publication of result. If 3-1-13 is treated as date of publication of result, that event, we are at a loss to understand how authorities were extending time in 14. Had the respondents intimated Rahul Priyadarshi in any of the letter for extension of time that he is to join within 1 year from the date of publication of panel, matter would have been different. The appointment was cancelled only on 27-10-14, i.e. nearly 1 year 9 months after the selection process was over. The ground reality is that since candidate is selected under a recruitment process and come in the merit list, maybe third, and when a person at serial number 1 doesn't, यही मैंने आपका इसी को डिस्कस किया है. It is not your case that this panel was eliminated. वो अलग बात है. In
Which page is the advertisement?
page, 1 minute, page, that will be page 36. Several posts were advertised. The top one is research assistant unreserved, 2 posts. में भी हम और भी 2-3 केस देखे हैं कि वैसे ही करता है। सब भारत सरकार की संस्था ऐसे काम नहीं करती।
These selection to these posts are governed by some rules, or is there any rule prescribed?
It will
In
be
fact, the advertisement does not disclose any procedure which was to be adopted for selection. Any procedure could have been adopted. That's a different matter.
This institution must have its own service rule. Central Civil Services Classification Committee. नहीं, वो नहीं दिया है। किस रूल से रेगुलेट? कुछ इंटरनल होगा। ICMR is a big organization. I presume, my lord, they must have service rules. Indian Council, this is a body of Indian Council of Medical Research.
It was a pioneer institute of Kala-Azar research at one point of time in the state and in the country. Such an important place, this is the way the appointments are being made. Nothing is prescribed, absolute discretion of the appointing authority. Everything.
Advertisement does not disclose. Advertisement does not disclose.
Yes, you are for the other side.
I'll be, before my friend starts, I'll be, my lord, referring to 2 judgments. One judgment I have annexed at page, annexure 12, a coordinate division bench of our own High Court, annexure 12, page 96. Especially paragraph 7 on page 97, relying on a Supreme Court judgment, waiting list cannot be a reservoir for making appointment from the list from time to time. that paragraph 7, my lord, of that judgment. We do not find that such stipulation in circular can be used as a permanent source of appointment. Decision of state government that panel would have life of 1 year is fair and reasonable. Once after expiry of 1 year, fresh selection process has been initiated and appointment made from that selection process undertaken. The appellant cannot claim right of appointment on the basis of panel prepared in the year 2013 in which her name appeared at serial number 59 as a wait-listed candidate. Similar issue has been examined by Honorable Supreme Court in the case reported in Kulvinder Pal Singh so and so, in which it has been held that waiting list cannot be used as a reservoir for making appointment from that list time to time. And Kulvinder Kulvinder Singh, my lord, has dealt with.
Yes.
That is reported in 2016, volume 6, SCC, page 532. Paragraph 9 to 12. Paragraph 10 onwards, it is fairly well settled that merely because name of candidate finds place in the select list, it would not give him.
Yes, Mr. Sahin, it is settled position.
Yes.
Yes. Yes, we have understood, Mr. Sahin. You want to rely on some judgment?
One query which has come from my lord. I find that they have, ICMR has its rules which says Central Civil Service Conduct Rules and Civil Service Classification Control and Appeal Rule are applicable to the employees.
Oh, that is different. That is conduct rules and classification control and appeal rules. That is for the purpose of taking disciplinary action and ensuring conduct of a government servant or an employee of the ICM. That is different.
They must have their own, my lord, set of regulation or guidelines to regulate process of a selection and appointment.
Yes.
May please your lordship. On 17th, your lordship was kind enough to ask a question. On 17th this month, your lordship was kind enough to ask a question from which date the panel is commenced. My lord, for that I draw your kind attention at page 37 of the running writ, my lord.
Page
37, my lord.
of
Running writ.
yes.
Advertisement is given, my lord. Candidates apply for the recruitment of the post. Screening is done. Accordingly, persons are invited for written test and viva voce is taken there, my lord. At serial number 2, my lord, expert is from Delhi, Calcutta, and last man is the chairperson of the RMRA, Mr. Pradeep Das, who has filed this appeal. My lord, there are 7 persons who are expert to recommend select the panel. Accordingly, panel has been arranged, my lord, and my candidature, my position comes at waiting list number 1. 1 year, 9 months time has been given to the petitioner, number 1, who has got the number 1, Rahul Pirdarsi. How long it can be given extension, my lord? I draw your kind attention at page 41 of this running date. My lord, it is issued on, this letter is issued on 28th July 2014.
What right did you have to be appointed on the basis of you being a waitlisted candidate?
Yeah, Milord.
That is the
I am
question.
coming to this, Milord. Milord, subject reference 1 is Milord Niche. First offer of appointment to Rahul was given on 5th February 13, Milord. This is the first reference of this letter. Thereafter, can the extension can be given for indefinite period? It is central government, Milord. I draw your kind attention at last page of the IE of the director, Milord.
Mister, the question is what is in your favor?
Law is in my
How
favor.
do you claim your right to be appointed on the basis of your position as a waitlisted candidate?
Yeah, Milord.
That is the only question.
Yeah, Milord. I draw your kind attention, Milord, that page number 16, Annexure A of my counter affidavit. This is the central government employee. Every service condition is regulated and being obeyed by the DOPT under Home Ministry, Milord. I have annexed a letter. How much extension can we give?
Where?
It is at page 16 from my counter affidavit.
Page 16 of your counter affidavit.
Yeah, Milord. That is Annexure A of 95 letter. It is the letter of DOPT of the year
16.
Milord.
Page 61, 16 or 60?
16.
The counter में पेजी है, उनके काउंटर में टोटल पेज 20 है।
Milord.
C on behalf of respondent number 1. C on behalf of respondent number 1. How many counter affidavits have you filed?
Milord.
How many counter affidavits have you filed?
I have filed one counter affidavit against the mandate, against IA, and then ultimately I have filed for vacation of the stay order.
All right.
Milord.
He is referring to the first counter.
First counter.
Yes.
Annexure A is an office memorandum.
Please place. Which part?
Page of my counter, that is 16, Milord. Annexure A.
Which part of page 16?
Which part of?
That is para second, Milord.
Yes.
All paras first and second say so. Last line is that an offer of appointment would lapse automatically after the expiry of 6 months from the date of issue of original offer of appointment. Original was given on 5th February 2013. It out to be expired in August 13. Thereafter I have got the right in view of the judgment of the Honorable Supreme Court that I have quoted in para 16. Para 17, my lord.
Yes.
Waiting list. Para 17, that is law which I have mentioned. First mentioned the, my lord, I have mentioned the directives, principle of state policy which the government,
Which page?
at page 8 of first counter affidavit.
Yes.
My lord, I have mentioned law. First law, part 4 of the Indian Constitution deals with fundamental duties of every citizen of India. Article 51AJ says that every citizen of India to strive towards excellence in all spheres of life, individual and collectivity, collective activity, so that the nation constantly rise to higher levels of endeavor and achievement. This has been interpreted by the Allahabad DB, my lord, who says in Ram Prasad, the state of UP and others, that the excellence means surpassing merit, time, virtue, honest performance, and dignity and eminence. My Lord, honest performance, DOPT later said that extension should not be given more than 6 months, and he has been given extension 1 year 9 months. Thereafter, panel has been cancelled. There was waiting list, my Lord. That is the Supreme Court judgment. In Gujarat State Activity versus State of Gujarat, and the report is waiting list prepared in service matters by the competent authority is a list of eligible and qualified who in order of merit are placed below the last selected candidates. Such lists are prepared either under the rules or even otherwise, mainly to secure that the working in the office did not suffer if the selected candidates do not join for one or other reason, or the next selection or examination is not held soon, my Lord. A candidate in the waiting list in order of merit has a right to claim that he may be appointed if one or other selected candidate does not join. This is very much clear in the Supreme Court judgment, my Lord.
A right to claim is different. You may have right to claim, but
The
right to be appointed is a different thing.
A candidate in the waiting list is in order of merit has a right to claim but that he may be appointed if one or other selected candidate does not join. Rahul Pridarshi did not join. Panel of the life of the panel is 1 year. It should not be extended after it should be extended up to 6 months. Thereafter it should not be extended. Rahul was given 1 year and 9 months. My right accrues from after the expiry of 6 months of extension time. That from that time my right accrues, my Lord, and I should be appointed.
You could have claimed.
The other I claimed.
You could have claimed after 6 months.
I did not know. The result was never published.
Not know is very difficult.
My Lord, just a minute, my Lord. I draw your kind attention to the running suit. Running writ, my Lord, where I have at page 77. That is which I have received from RTI. बहाली हेतु विज्ञापन निम्न समाचार पत्रों में दिया गया. That is column number 1. दैनिक एम्प्लॉयमेंट न्यूज 11-17 जुलाई 2009. हिंदुस्तान हिंदी समाचार दैनिक पत्र पटना संस्करण दिनांक 11/7/9. दैनिक जागरण हिंदी पटना संस्करण दिनांक 10/7/9. क्षेत्रीय नियोजनालय पटना से भी नाम मांगा गया था. संस्थान परिषद के वेबसाइट पर भी प्रकाशित किया गया था. दिस इज द मोड ऑफ एडवर्टीजमेंट, मिला. नाउ इन आरटीआई योग्यता क्रम सूची से मिला serial number 6 of this RTI letter, which I received a reply from the director of the institution. योग्यता क्रम सूची का प्रकाशन समाचार पत्रों में नहीं किया गया, नहीं इंटरनेट पर दिया गया, क्योंकि उस समय इंटरनेट का प्रचलन कार्यालय में नहीं था. वेबसाइट था मिला, लेकिन नहीं दिया. संबंधित व्यक्ति को कार्यालय पत्र के द्वारा सूचित किया जाता है. चयनित सूची संचिका में ही उपलब्ध है और उसी के आधार पर चयनित उम्मीदवारों को बहाली पत्र भेजा गया था. How could I know, my Lord, when it is kept in file and it is under the custody of the director? I cannot say the director, you publish the result. Then I filed RTI when I waited for a year. And
When was the last exercise of selection process completed? On which date?
pardon me, Lord?
On which date the last exercise in the selection process was completed?
Selection was completed, process was completed on 3rd January 2013.
That was the date of Viva Bosi.
That was the date of Miller.
What happened on that date?
Selection process was published and it is given to the director in the process.
Mr. Counsel, you participated in the selection process.
Yeah, my Lord.
What did you do? You went and appeared for interview.
I went for an interview. And
Which date? That is what we are asking. What is that date?
That is 3-1, my lord. 3-1-13.
3/1/13.
3-1-13.
And after that till 16 you didn't find any reason to inquire what was going on.
And I cannot ask the director, my lord. There is a Supreme Court judgment, my lord. I cannot quote at this stage. The authority, just we see, my lord. So persons are waiting publication for, go on hunger strike for publication of the result.
Mr. Counsel, you have filed this counter.
My lord?
You have filed this counter.
Yeah, my lord. I have filed this counter.
What is your name?
My name, Hira Prasad Pandey.
And the petitioner is your son.
Yeah, my lord.
And you have shown the affidavit.
Pardon, my lord?
You are conducting case of your son.
Yeah, my lord.
Ask someone else to appear.
Pardon, my lord?
Ask someone else to appear. We will not hear you.
This can't be a professional venture for you. You are appearing with band and everything. What is this?
I am a lawyer, my lord, here, Patna High Court and also in the Supreme Court.
Mr. Counsel, please engage someone. The petitioner is your son. Respondent. Let's discuss tomorrow. He can assist.
He can assist in person. It can't be a professional venture for you. You are appearing as if you are appearing as a counsel. You have taken fee from your son.
No, my lord.
Then what is this?
Pro bono. Engage someone. It's not proper.
वही कैंडिडेट
कल थोड़ी देर के लिए accommodate सिर्फ करें।
Tomorrow?
Tomorrow, my lords may accommodate for little time.
All right.
I have a first matter before another high court
All right.
virtually.
Item number 3, PWC number 2704781, Murthy Devi versus District of Bihar, petitioner Mr. Pankaj Kumar Jha.
My lord, in this case, my lord, may I pray to your lordships one thing, my lord, let this case be treated as parted, because it will be argued tomorrow, then it will be at the top of the list. It was heard.
No, let it come.
My lord, may I permitted to withdraw this application?
Learned counsel for the petitioner seeks permission to withdraw this application. This application is dismissed as withdrawn. Any liberty?
Yes.
Is what?
No, no liberty.
इसमें लॉर्डशिप हम रेस्पोंडेंट 19 की तरफ से हैं रेस्पोंडेंट
Give
19
your slip.
Obliged.
Under the heading for judgment, item number 4, PWC number 192001 of 21, P.P. Kumar Singh versus State Bank of India.
The petitioner, please take your seats. Claims that he is holding the post of Chief Manager, State Bank of India, Stressed Assets Management Branch, Patna, and a member of the SBI Officers Association, comma, Patna Circle. Stop. He further claims that he is contesting the election of the Central Committee of the said association. Stop. This writ petition was filed on this writ petition has been registered on 16/11/2021. When did you file?
Filed on 30/10/2021 on the portal.
The writ petition was filed on 30th of October 2021. Stop. From annexure 2 of the writ application, it appears that the program for the election, namely triennial general election 2021-2024, was notified on 1/8/2021. Stop. The last date of withdrawal of nominations was prescribed as 15/9/2021, publication of list of contestants on 15/9/21, and the date of polling as 31/10/2021. Stop. Next, as would be evident from the cause title of the writ petition, apart from the State Bank of India and the registrar/additional registrar Shramik Sangh bracketed Labor Union Government of Bihar, there is no official respondent impleaded in the writ application. Full stop. Next, the petitioner has the petitioner, after having participated in the process of selection by filing nomination papers, etc., has filed the present writ application seeking following reliefs. Paragraph 1, Roman 1, 2, Roman 5. Oh, stop. It is evident from the relief is the petitioner is seeking that he wants a declaration that clause 14 bracketed Roman 2 of the bylaws of the association is opposed to the principle of free and fair election, and as such it needs to be amended in consonance with the object to hold election of the central committee of the said association. Stop. The petitioner is further seeking a declaration that clause 14 bracketed Roman 21 of the bylaws which permit the election committee for scrutiny of ballot paper may nominate independent observer but not in consultation with a member of outgoing central committee, including the general secretary who intends to contest the election. Full stop. Next, a copy of the bylaws has been brought on record by way of annexure 1 to the writ application, from which it transpires that the bylaws were framed in at least in 1998. Oh, stop. The petitioner apparently did not raise any grievance before any forum in respect of legality / correctness of the aforesaid provisions of the bylaws before filing this writ application after having participated in the process of selection, process of election. So stop. From reading of the averments made in the writ application and subsequently filed interlocutory application registered as IA number 1/2021, it transpires that the petitioner has made several allegations against private respondents. First off, he is not seeking any direction either to the State Bank of India or to the registrar / additional registrar Samik Sangh, respondent number 6. So stop. Next. After filing of the registration of the writ petition on 16/11/2021, the petitioner filed an e-mentioning for urgent hearing of this matter on 14/12/2021. First off, the request for expeditious hearing of the matter was accepted, and accordingly the matter was listed on date they close. So stop. The court at the very outset.
You have the date? Was mentioned.
17. 17. The court at the very outset wanted learned senior counsel appearing on behalf of the petitioner to satisfy this court on the question of maintainability of the writ application involving election disputes in relation to internal affairs of a private association discharging no public function. Full stop. Next. Mr. Umesh Prasad Singh, learned senior counsel appearing on behalf of the petitioner, emphasizing that this writ application under Article 226 is maintainable, has vehemently argued that as the petitioner has no alternative statutory remedy against the irregularities being committed by the private respondents, the petitioner has a right to maintain this writ application. So stop. He, in support of his contention, has placed reliance on Supreme Court's decision in case of Maharashtra Chess Association versus Union of India, reported in 2020, volume 13, SCC 285. Any other decision?
Patna PL Jar 1962.
And AIR 1962 and Mukund, and a decision of this court in case of Mukundaram Tati versus SI Raja Registrar Trade Unions, Bihar Patna and other respondents, bracketed AIR 1962 Patna 338. Full stop. Any other thing on the question of maintainability?
No, my lord.
Next. Mr. Amish Kumar, learned counsel representing the State Bank of India, on the other hand, has placed reliance on a division bench decision of this court in case of Bokaro Steel Workers Union and another versus the state of Bihar and others, reported in 1995, volume 1, PLJR 400, to contain that after considering the earlier division bench decision in case of Mukundaram Tati, the division bench has specifically held that in the absence of any provision in the Trade Unions Act, any dispute in relation to election can only be resolved by means of a suit before civil court. Stop. Next, in our considered view, the Supreme Court's decision in case of Maharashtra Chess Association versus Union of India has no application in the facts and circumstances of the present case to establish maintainability of a writ application raising election disputes of a private body. Stop. The said decision of the Supreme Court in Maharashtra Chess Association has been rendered in a different context altogether, where the parties by way of contract had agreed to submit their dispute to only one amongst several courts having jurisdiction, to the exclusion of all other courts. Full stop. In the aforesaid background, the Supreme Court held in case of Maharashtra Chess Association that jurisdiction of a writ court cannot be excluded by the parties to a contract. First off, the said decision in our considered view has no application at all. First off. Next, the decision of division bench of this court in case of Mukundaram Tati, as bracketed supra as relied on by learned senior counsel, does not support his contention in respect of maintainability of the writ application. First off, in case of Mukund Ram Tati, the Supreme Court, while considering the jurisdiction of the registrar of the trade unions, has held that registrar of the trade unions has full jurisdiction to inquire about legality of the new election of the office bearers of a union for the purpose of maintaining a proper register showing the names of the office bearers who may be at the relevant time required to comply with the provisions of the Act or to be dealt with in accordance therewith. Full stop. The said division bench decision in case of Mukund Kumar Tati has subsequently been considered by division bench of this court in case of Bokaro Steel Workers Union and others, bracketed Supra, and it has been specifically held in paragraph 22 as under. Stop. This is also to be noted that learned counsel for the respondents have referred to decisions of Madras High Court in case of KAS Kaushik versus State Bank of India in WP number 18397 of 2016, decided on 10/6/2016, as well as Rajasthan High Court in case of OP Gupta versus Union of India and others in do you have the case number? OP Gupta. Decided on 14/9/2000. Give us the number of the case. Reported in 2001 ILLJ 831 RAJ Rajasthan. Whereunder the courts have held that writ petition under Article 226 of the Constitution of India raising election disputes in respect of associations registered under the Trade Union Act cannot be maintained. Stop. Next. After having considered the rival submissions advanced on just our attention has also been drawn to clause 17 of the bylaws, which lays down dispute redressal mechanism in respect of any provision under the bylaws. First off, clause 24 of the said bylaws permits the association to amend, alter, replace, rescind or add the bylaws at any time by passing suitable resolution by a majority of the members present in the General Council and oblique or a special general meeting or through a referendum. So stop. Next. Stop. Next. In our view, in the wake of the facts of the case as noted above and the law laid down by this court, coordinate bench of this court, in case of Bokaro Steel Workers Union and other, in our view, this application under Article 226 of the Constitution of India cannot be maintained. Stop. This is accordingly discussed. This application is accordingly dismissed.
Under the heading further on item number 5, AWDC number 5366021, Mr. Kumar has concluded filing the case versus the state of Bihar for the petition of Bihar last week. Mr. Kumar for the
दो ही क्या रखा है May I please, Your Lordship? My Lordship has asked for the order dated 2/11/2020. I have placed that, my Lord. This was with respect to the vehicles sought to be registered in Delhi itself. But here also, my Lord, Your Lordship will find that whenever an intervention was filed for registration of a vehicle or denial of registration by other state, the Honorable Supreme Court has directed those petitioners to approach the concerned High Court in the matter, my Lord, where the registration by other states were denied, because in the order dated 13/8, the Honorable Supreme Court has specifically held that that order was for the rest of the country. So far as Delhi was concerned, no registration was to be done. That is Annexure 2, my Lord. If Your Lordship will come to page 25, my Lord. This is the order dated 13/8/2020, Annexure 1, my Lord. Sorry, Annexure 1. Page 25, my Lord. Second paragraph, my Lord. We order that in the Delhi and NCR, no registration of the vehicle of BS4 is to be made after
Which
31/3.
page? 25?
Page 25, my Lord, of the writ petition.
Of the writ petition, yes.
Note second paragraph, my Lord.
Yes.
We order that in the Delhi and NCR, no registration of the vehicles of BS4 is to be made after 31/3/2020. This order is for the rest of the country and only due to lockdown and not to be used for any other purpose, reason, and for registration of other vehicles of which registration was not done for any other reason. So this 13/8/2020 was with respect to the entire country, my Lord. And thereafter, my Lord, several matters were taken up with respect to Delhi, like Municipal Corporation Delhi wanted some vehicles to be registered. Delhi Cantonment Board wanted some vehicles to be registered. Those matters were subsequently taken up, and 2/11/2020 was with respect to those vehicles, my Lord. So therefore, my Lord, that order may not be relevant for the purpose of this case, my Lord. So far as my case is concerned, the registration.
Are you disputing the fact that inter-se registration was
Dealers.
Inter-se dealers registration was prohibited?
No, my Lord, that bar was placed by the Honorable Supreme Court that if a sale has been effected because of a sale inter-se dealers, like one dealer selling to other dealer, In those cases, the genuineness of the sale was to be looked into, and the Honorable Supreme Court has come to a conclusion since large number of such cases had been reported. Therefore, they can't be accepted as genuine sale, and therefore the registration was not permitted.
So who are dealers?
Dealers are the authorized representatives of the
Is it
manufacturer.
defined in the
Yes,
Motor
my lord.
Vehicles Act?
It has been defined, but the definition of dealers as given in the Motor Vehicle Act 1988 is 2 subclause 8, my lord. Dealer includes a person who is engaged in building bodies for attachment to chassis, or in the repair of motor vehicles, or in the business of hypothecation, leasing, or hire purchase of motor vehicles. This is the definition, my lord. I am the dealer of the company, my lord. So I have purchased,
Where is the definition?
my lord, section 2, my lord, subsection 8. I would be the purchaser directly from the company, my lord. I have not purchased it from any other dealer. So I don't fall into that bracket of the bar imposed by the Honorable Supreme Court, my lord. And so far as the division bench judgments are concerned, my lord, the 2 division bench judgments which has been brought to your lordship's notice through the supplementary counter affidavit, your lordship would find that the prayer there was to reopen the portal so that the details could be uploaded. That was refused by the Honorable division bench, my lord. Whereas in my case, all the details have already been uploaded. We had uploaded details of 4 vehicles. 2 had been registered, but 2 is being denied only on the ground that it is sought to be registered in the name of the dealer. That is the only reason they have given. That is based on that earlier communication of 21/8/2020, whereas subsequently that part has been removed by the state itself, by the communication dated 7/9/2020, which has not been taken notice of. If your lordship will see, once again, the earlier communication is Annexure 3, page 28. The last line of that page, my lord, if your lordship would see, there are 2 situations which has been communicated, my lord. Have your lordship got it? Page 28.
Yes.
Yes, my lord. एक डीलर से दूसरे डीलर के नाम, this is in consonance with the direction of the Honorable Supreme Court in sale inter se dealers, अथवा डीलर स्वयं के नाम से विक्रय कागजात होने की स्थिति में निबंधन नहीं किया जाए. Now this part, the second part, अथवा के बाद वाला जो part है, that has been removed from the next communication, which is Annexure 4 at page 30, which they have also annexed through the supplementary counter affidavit, my lord. My lord, may I just request your lordship to have the supplementary counter affidavit, because that document is clear in that.
You are relying on Annexure 4.
My lord. This is Annexure M to the supplementary counter affidavit also, my lord. My document is not very clear, my lord. I am extremely sorry for that.
So according to you, they modified this Annexure
Yes,
3
my lord.
to that extent.
Annexure 3 has been modified to that extent by Annexure 4. And that is the specific statement which I had made in para 16, which they have not denied even today. In para 25, they have answered para 16. They say that yes, we have issued 7/9/2020.
We will be back to it.
Obviously. पेशकार साहब कितनी देर में? अच्छा
हो गया अर्जुन लेकर आइए अर्जुन
Yes, you were referring to Annexure 4
Annexure
is-
M of their
M.
M of their supplementary counter affidavit.
Yes.
my lord. That is probably at page 77. No. 86. 86. Page 86, my lord, Annexure M. Here your lordship will find in clause 2, if the BS4 vehicles are found to have been sold inter se dealers, the registering authority can reject such application for registration, full stop. The other part, Swam ke naam se, is missing in this, my lord. It has,
The date of the, both the letters are same.
yes, my lord, both the letters are same, my lord. I have annexed Annexure 4, which is not very clear, my lord. And therefore I was referring to this because the
Right.
copy is clear, my lord. Even before that, my lord, by Annexure I, my lord, if your lordship will see page 76, this is of April 2020, 25th of April 2020. It just simply says, BS4 वाहन जिनका शुल्क ऑब्लिक कर दिनांक 31/3/2020 तक वाहन 4 में जमा करने की कार्रवाई संपन्न कर ली गई है, वैसे सभी वाहनों का निबंधन किया जाएगा। Therefore, it has been consistently the policy of the government also, in conformity with what the Honorable Supreme Court has said, that if a sale has been effected inter se dealer to avoid any situation, those sales are not to be recognized. But here there is no question of sale inter se dealer, my lord. And as the petitioner himself being the purchaser, and there being no bar under the Motor Vehicles Act for registration in the name of a company or an organization, his vehicle should have been registered, my lord. The only reason which they give is on the basis of 21/8/2020, that since...
Is there any order rejecting your application?
Yes, my lord. That is the last document, my lord. Annexure 5, page 31. This is on 23rd of November, and they only refer 21/8/2020, my lord, without referring the subsequent instructions. It says, उपयुक्त विषय के संबंध में सूचित करना है कि माननीय सर्वोच्च न्यायालय के न्यायाधीश के आलोक में परिवहन विभाग द्वारा पत्रांक 5992 दिनांक 21/8/2020 के द्वारा दिए गए निर्देश में स्पष्ट वर्णित है कि एक डीलर से दूसरे डीलर के नाम से अथवा डीलर स्वयं के नाम से विक्रय कागजात होने की स्थिति में निबंधन नहीं किया जाए।
Yes. You have not taken into account your own decision, subsequent decision.
No, no, no. Our submission is the annexure 4 or my annexure M is not the amendment letter to the annexure 3. Yeah. Actually, the purpose of issuing annexure M is quite different. Kindly have a look on annexure L, page 84. That is annexure 3 to the petition also. I have just annexed it.
Yes.
This letter has been issued by the Principal Secretary, Transport Department, addressed to the DTO, who is the registering authority. And the direction is कि एक डीलर से दूसरे डीलर के नाम से अथवा डीलर स्वयं के नाम से विक्रय कागजात होने की स्थिति में निबंधन नहीं किया जाएगा।
Where is that? Where are you reading?
Page 84 in my supplementary affidavit.
Yes, annexure L.
It is also annexure 3 in the writ petition. It is same here. This letter has been issued by the Principal Secretary.
21/8/2020.
5992.
21/8/2020.
Dated.
That is what we are observing, that you are rejecting based on this. Why have you not taken?
Let me place my submissions. Yes. This letter has been issued by the Principal Secretary, Transport Department, to the DTOs of Bihar, giving the guideline, the direction to not register this. Then the next letter, that is annexure M, that is annexure 4 to the petitioner, petition. This letter has been issued by the OST Miller to the director NIC, just to say him, you enable the Vahan web portal to have the registration of those vehicles only who has been directed to be registered via annexure L. From Officer on Special Duty Transport Department to Rana Pratap, Technical Director, National Informatics Center, Patna. And the last line of this letter. In view of the above, you are requested to provide the said provisions in Vahan 4 to enable the process of registration of BS4 vehicles. So my submission is, this is not the amendment letter. This is the letter to the NIC so that you enable the Vahan portal. Earlier it was closed for the VS vehicles after 1st April 2020. The registration of BS4 vehicles were closed in the Vahan portal from 1st April 2020. So to restart that, to enable the Vahan portal, the director NIC has been said, you just enable them to register these things. So this is quite different.
21/8/2020 letter was issued in the light of certain direction by Supreme Court. Where is that part of the direction where intra-dealer sale cannot be permitted?
For that, my lord, that is intra-dealer sale has been dealt with that, but it is our interpretation to that. So it is come in the annexure L or 3, my lord. And
no, this 21/8/2020 is based on Supreme Court's decision.
My lord, both.
Where is that part of the Supreme Court's order?
Lord, it has to be read and interpreted in that way. The Supreme Court order in annexure 1, my lord. Kindly have a look on page 24 of the writ petition. May I guess that page 24.
No, you have prohibited something.
My lord.
There must be some reason behind that.
My lord.
What is that reason?
So we want to that the dealers do not play with the rules or misuse the rule.
So this is your own imagination or in the light of any observation made by Supreme Court?
In light of the observation made by the Supreme Court.
Where is that part?
Annexure 1 of the writ petition, the order is there. Page 24 may be seen. of the writ petition.
If there is any order, then any communication, notification or no notification, everyone will have to comply with that. Where is that?
Page 24, may I place it?
Yes.
From the third line.
Which page?
Annexure 1, page 24.
Yes, where?
From the third line.
Third line from the top.
From the top. We disallow the registration on the basis of such kind of transactions interstate dealers, as they are not sales to the customers, and registration of these kind of vehicles cannot be allowed. There is a flurry of misuse of the order, and such vehicles cannot be permitted to be sold in market now. They are not genuine transaction of the sale to the customers. Hence, no registration of such kinds of vehicles shall be made, which are sold interstate dealers during the lockdown.
So where is this observation of the Supreme Court that swam in the dealer's name is not permitted? And where is this stand in the counter affidavit that you are arguing?
Milord, in Annexure 27, in paragraph 27 of the supplementary affidavit.
Yes. What does it say? Read it. You read from paragraph 25 onwards. Where have you said?
25.
Apart from interstate dealers, where have you said in the counter affidavit, relying on that last line of the Annexure L, that it continues? Yeah. Where have you said that it continues?
Yeah. Actually, I have replied of paragraph 16 in 27. Paragraph 27, Milord, in the page number 51 of my supplementary affidavit.
Yes, that is what I am asking you. Where have you said that that continues?
Page 52.
Other than interstate dealers, Mr. Counsel, be very conscious what we are asking you to show. You are arguing that apart from interstate dealers, registration in the name of the dealer himself is also continues to be prohibited. So where is this averment in the counter? Show me, show us. The Honorable Apex Court's order you have just read, it only says interstate dealers. Your Annexure M also says interstate dealers. Your counter affidavit also says only interstate dealers. So from what is the basis of your submission that in the name of the dealer also registration cannot be permitted?
That is Annexure 3 only. It is our interpretation to that.
So that is what we are, Mr. Counsel, you are saying that that was just a communication to the NIC. That is not just a communication, that is reiteration of the Honorable Apex Court's order.
My friend Counsel was submitting that it is the amendment to the Annexure 3. That's why I am
It is not an amendment, it is reiteration of the observations or directions of the Honorable Apex Court's order.
My submission is that both letters are for two.
Mr. Counsel, we are putting a different question.
Yeah.
Now, if a dealer wants to purchase a vehicle, how can that be done? Whether the vehicle can be registered or not, could be registered or not?
In general course, it could be registered.
How? From where will he purchase? From where the dealer will purchase?
It can purchase from himself.
From himself?
In the name of the firm, he can purchase. It is, but here, for BS4 vehicles, the Supreme Court, Honorable Supreme Court saying that to just the misuse of that purchasing.
Therefore we are asking.
On the very last date, on 31st March,
therefore we are putting this question.
Near to the midnight, it was. हजूर जब कहीं नहीं बिका तो बस बचाने के लिए अपना सेल्फ परचेज कर लिया, so that it could be used.
Why not? That is the query of the bench. Why not? What prohibits?
And the coordinate bench of this honorable court had also in that case also, it has been self purchased by the
See, under section 2(8), dealer is defined. Had it been your case that the purchase was from one of the dealers as per the definition in section 2(8), then of course interstate dealer, it would have become a sale interstate dealer. That is not your case. The Honorable Apex Court's order is clear. It only says interstate dealers. Your notification or letter or communication annexure M also says that. Your counter also says only interstate dealers.
I am relying on.
Where are you?
I am relying on annexure L, my lord.
That is why we are saying, why are you not considering annexure M? Why only L?
Because M is addressed to the Vahan portal NIC, not to the DTOs, my lord.
You will have to justify even annexure L.
That may be a wrong submission, my lord. In the bottom it is.
That copy has to be given everywhere.
You will have to justify whatever you have prescribed in annexure L. You will have to justify. What is the basis? Supreme Court's direction may be a basis. But you will have to demonstrate that this was the direction of Supreme Court. Had there been no direction of Supreme Court, could you put any such bar?
Our interpretation to that extent that it can be purchased for misuse of in the sense that at the last moment we purchased and we could resell in the market.
That logic will not serve.
And that is not based on your pleadings. There is no such case in the counter what you are arguing. They are only saying in light of annexure L. Our query is, what is annexure M? Is it a fruitless, pointless exercise by the state? You see what you say at the last of annexure M at page 88, to ensure compliance of the directions of the Honorable Supreme Court. And what is the direction? Interstate dealers. So from where are you? This is what we are trying to understand. You are arguing something, there must be some basis somewhere.
So far, my lord, I understand.
Yes.
No, so far I understand annexure M has been issued in a different perspective, my lord. It has been issued to the NIC because the Vahan portal has been closed from 1st April 2020 to register the vehicle of BS4. To restart that in light of annexure M or in the light of Honorable Supreme Court order, we have directed the director NIC to just to enable the portal, Vahan portal. For that purpose, the annexure M was issued. And for purpose of registration, my lord, annexure L was issued to the DTOs, my lord, where that has been directed. Annexure 3 and Annexure 4 or the Annexure L or M have been issued to the two different places. One to the DTOs by the Principal Secretary, one by the OSD to the NIC Director NIC. If it was so, it should be issued by the Principal Secretary.
Yeah, just small exercise here.
OSD is a very small post. In the last line of part 27 of my supplementary, I have written letter number 6372 dated 7/9/2020 is addressed to the technical director NIC Patna to enable the Vahan web portal for such registration. Page 52, my lord. Proper 3 lines. You have explicitly written this. Letter number 6372 dated 7/9/20 is addressed to technical director NIC Patna to enable the Vahan web portal for registration. It has different perspective. This is not the amendment letter to the next 3, so-called 3. And this is our reply to the para 16, to which Krishna is relying.
What is FADA? FADA?
Federation of Automobile Dealers Association. Federation of Automobile Dealers Association.
So in your case, sale was uploaded on e-Vahan portal.
Yes, madam. That I have specifically mentioned in my writ petition also, my lord, with the receipt numbers. And 2 have been registered.
Your objection is only that because of he is a dealer, not that whether it was uploaded or not uploaded.
No,
those
it was
issues.
uploaded.
That is
the
all
last moment, so
admitted.
it is admitted position. So. Of course, it was uploaded in the midnight.
Para 13 and 18, my lord of the writ.
You are buying it from which entity?
Pardon, my lord?
You are buying it from which entity?
Honda Motors, my lord.
Huh?
Honda Motors.
Honda Motors.
That is Annexure 2.
Then why
I've
have you
got
made
the
this
original.
statement in paragraph 1?
Pardon, my lord?
Come to your paragraph 1.
My lord.
Vehicle of petitioner in the name of petitioner.
Refusing to register a vehicle of petitioner company in the name of the petitioner company.
Oh.
They say this is only one. Paragraph 25. Supplementary
Why did your transport commissioner incorporate this provision? This is what we want to know. In Annexure L, why was this incorporated? अथवा डीलर स्वयं के नाम से निबंधन नहीं किया जाए, भाई?
Actually, it was the practice that we thought that if he sold to
Mr.
himself.
Counsel, we are worried about only two aspects. Otherwise, he has been able to make out a case. We are worried that no order passed by us should go against any observation made by Supreme Court. 1. 2. Even beyond the Supreme Court's decision, the state government, in the facts and circumstances, could have taken a policy decision that even these transactions are may suffer from some kind of fraud or illegality or
We suspect fraud in this case.
your suspicion will not do. You are simply relying on Supreme Court's decision. We are not finding anything in the Supreme Court's decision which prohibits such registration. So we are worried about only two things. Otherwise, we don't have any difficulty.
Lord, recently, they have been registering vehicles in the name of dealers, my lord. Unfortunately, I don't have the details of those registration. Prashant Honda Muzaffarpur and Solution Honda Gaya, they have got their vehicles registered.
Ask the Transport Secretary to be here. Explain the circumstance in which this was issued. Ask him to be here. When?
Day after tomorrow.
Despite our all sincere efforts, we have not been able to discern the circumstance in which the Secretary, Transport Department, Government of Bihar, in his letter dated 21/8/2020, issued to all the district transport officers of the state in compliance of a Supreme Court's order dated
13/8/2020, but it is not referred in this 21/8.
13/8/2020, passed in WP bracketed S civil number 13029 of 1985, has put a bar on registration of BS4 vehicles in the name of a dealer himself, comma, dealer himself. So stop. Let the Transport Secretary be personally present in court to answer, to clear the confusion on Thursday. Stop. He will have to satisfy this court as to the said bar is in furtherance to which direction of the Supreme Court and in compliance of or in compliance of which provision of law. At 10:30.
Item number 6, CWJC number 6415 of 21, Manisha Kumari versus the State of Bihar. For the petitioner, Mr. Kumar Abhimanyu Pratap, Mr. Kumar Devashish.
Your Lordship, this case come on my mentioning for urgent hearing on the basis that my case is covered by four judgments of this Honorable Court. The issue is, Lordship, cancellation of PDS license, and the Honorable, without hearing me, without giving inquiry report to me.
You can prefer appeal.
Lordship, I have annexed two orders of this Honorable Court, to the effect that as no inquiry report on the basis of which license has been cancelled.
You are right.
Lordship.
You are right that there are decisions of this court there are decisions of Supreme Court, but suppose if we direct the state to file counter affidavit and adjourn the matter for 2 months, after 2 months where your matter will be listed we don't know, and when your case will be taken up, that too we don't know. Therefore, you prefer appeal. The appellate authority has a duty to dispose it of within some prescribed time. That will expedite your learned counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with a liberty to prefer appeal against the impugned order of the licensing authority before the appellate authority. Stop. Considering the facts and circumstances, this application is permitted to be withdrawn with the liberty as sought for. Stop. If any appeal is preferred within 4 weeks from today, the appellate authority shall liberally consider the petitioner's application for condonation of delay and decide his appeal on merits, instead of dismissing the same on the ground of limitation.
Not to kindly fix a time, Lordship.
There, go there. Time is there under the rules, under the order.
Item number 7, CWJC number 9616 of 21, Nalanda Injicon Private Limited versus the State of Bihar. For the petitioner, Mr. Shekhar Singh, Mr. Satyendra Rai.
Lord, pursuant to last order, may I kindly see the last order?
Yes.
Lord, the appeal preferred by the petitioner has been disposed of by the appellate authority. Lord, the initial date was fixed of 29th. Thereafter, on the request of the petitioner, it was heard on 2nd of December. Thereafter, after written argument, it was disposed of on 15th February. Lord, I will file affidavit if your lordship so.
So what have you set aside?
Lord, it has been Lord, the remanded back, but the order has been stayed. The blacklisting order has been stayed.
मिलोड आई डोंट नो मिलोड इन्होंने अभी पढ़ाया हमको
हम पढ़ाए थे
हाँ हम तो कह रहे हैं इन्होंने पढ़ाया आई डोंट हैव द कॉपी एंड नॉट बीन कम्युनिकेटेड ऑर्डर इट अपीयर्स टू बी समव्हाट मिलोड इफ योर लॉर्डशिप विल सी पैराग्राफ 5 ऑफ द ऑर्डर अपील संबंधी दोनों पक्षों को सुना सुनवाई क्रम में संगत तथ्यों को विचार करते हुए ऐसा प्रतीत होता है कि अपीलार्थी द्वारा समर्पित स्पष्टीकरण पर मुख्य अभियंता द्वारा सम्यक विचार करते विस्तृत तार्किक आदेश पारित किया जाना चाहिए था, जो इस मामले में नहीं किया गया था। इस मामले को न्यायसंगत सुनवाई करते हुए विस्तृत तार्किक आदेश पारित करने हेतु मुख्य अभियंता आयोजन निरूपण और श्रवण को रिमांड किया जाता है तथा मामले के निष्पादन तथा अंतिम आदेश पारित होने तक मुख्य अभियंता द्वारा अपीलार्थी के ब्लैक लिस्टिंग के आदेश को स्थगित किया जाता है। इट शुड हैव बीन क्वाश्ड मिलॉर्ड, व्हाट आई से मिलॉर्ड, इफ द मैटर इज बीइंग रेमिटेड बैक and you are not satisfied with the original order, then it ought to have been quashed in the matter.
Effectively, what will be the difference for you?
हमारे लिए difference होगा नहीं, उसे नहीं, he will be prejudiced by that order, my lord, because that has not been quashed, because that is what the Supreme Court also says, my lord.
What is the difference?
You will be swayed by the, you will like to sustain the original order, therefore, my lord.
That can happen even otherwise, Mr. Sinha.
My lord, that can happen, my lord, I don't say, but that is what the Supreme Court says, my lord. You will be assuming that
today there is no difference in staying or quashing. Today you cannot claim any.
No, I am not claiming. I am only, my lord, apprehending that something will be playing in his mind, my lord, once he again decides the matter. So therefore it should be clarified, my lord. Virtually जब इन्होंने क्वाशी कर दिया है, as he says, my lord.
Show us the
हुजूर ने कहा था कि अपील का रूल्स में लिमिटेशन ये सबके लिए हुजूर ने कहा था ऑर्डर में।
Lord, for that, my lord, the Advocate General has, my lord, given opinion and it is being taken care of.
कि अपील मेरा 1.25 साल से पेंडिंग था हुजूर, इट वाज नॉट बीइंग डिसाइडेड. There is no time limit prescribed, my lord. For filing appeal, my lord, 30 days period is there.
Yeah, but you are not now.
No, no,
matter,
no. My lord wanted, my lord, both of your
That
lordships
was
wanted, my
general
lord.
observation. They must prescribe some
Time limit, my lord.
time limit. That regard may be had to this court's order dated 23/11/2021. First off, passed in this case. Stop. Grand Council representing the state of Bihar.
Lord, I am for the Budco, my lord.
Or the Budco has produced before us an order dated 15/12/2021 passed by the Principal Secretary cum Appellate Authority, Urban Development and Housing Department, Government of Bihar, whereby the matter relating to blacklisting of the petitioner for 2 years by the Chief Engineer, Design, Planning and Monitoring of the department has been remanded back for passing a fresh order. First off, the Appellate Authority has noted in the impugned order dated 15/12/2021 that the original authority failed to pass a detailed reason order while blacklisting the petitioner. First off, further, till final order is passed by the authority, the Appellate Authority has ordered that the order of blacklisting shall remain stayed. Next, in such view of the matter, in our opinion, the petitioner's grievance has been substantially redressed with the passing of the appellate order, inasmuch as the order dated 10/11/2020, impugned order dated 10/11/2020 of blacklisting is no more in force till a final order is passed by the original authority. Stop. This application stands disposed of accordingly. We are keeping this smell.
कॉफी दे दीजिए सर.
8 CWJC number 10178 of 21, Ashok Kumar Sinha versus the State of Bihar through the Principal Secretary. For the petitioner, Mr. Rakesh Kumar Jha, Mr. Ram Nivas Prasad. For the state, Mr. Manoj Kumar Ambassador,
for the Bihar State Election Authority. My counter is ready. Should I file physical or?
Counter affidavit may not be required.
Yes.
Yes.
Lordship.
Lordship, for the constitution of the managing committee in the AG Housing Cooperative Society, election, voting, counting and declaration result all was done on the 30th of January 2021, Lordship. The Bihar State Election Authority, Lordship, is a body constituted for preparation of the voter list and for conducting of the election. But why the Annexure 4, Lordship, as page 47, Lordship, the Bihar State Election Authority, who is just conducting the election, has set aside the entire election, including the petitioner. Petitioner is one of the elected person. He is the elected secretary, Lordship. So may I read the order, Lordship?
So you are challenging this Annexure 4?
Annexure 4 and Annexure 5, Lordship. Actually, Lordship, in view of Annexure 5, the election has been declared void. It is the claim that by the Annexure 5, Lordship, for unavoidable reason, election process has been stayed by the Bihar State Election Authority. And despite that, election has been conducted by the election officer. Therefore, election authority has, under its power and jurisdiction of superintendence, direction and control, had set aside had declared the election void ab initio, Lordship. I have challenged both Annexure 5 and Annexure 4, Lordship. Annexure 5 is also illegal, unwarranted, and futile, Lordship. And the contrary to the well-established.
Annexure 5 you have challenged?
Yes, Lordship. Annexure 5 I have challenged, Lordship.
Because it is beyond jurisdiction.
Lordship, beyond jurisdiction, Lordship. Because the election, there was no aparihar reason.
That is difficult for us to say whether aparihari or not.
Because for adjudicating the disputed issue, there is a well-established principle of law since 1952 Puniswamy case. While the election process is going on, all disputed questions should be thrown out and election has to be conducted on time as per the scheduled program. For deciding some voters whether their membership are valid or invalid, the Bihar State Election Authority stayed the election, Lordship. Although the Bihar State Election Authority has no jurisdiction because the membership issue in cooperative is vested with the cooperative registrar, Lordship. So even if as on today, Lordship, election will be conducted that on the same voter list. And the voter list was the same, Lordship, on the basis of the last election was held. There is no change in the voter list. And on the basis of the private complaint of the respondent number 9, Lordship, who was the elected person of the same voter list in the year 2018, he had challenged the voter list.
Who has to conduct election?
Bihar State Election Authority, Lordship.
Who had conducted election?
The conducting officer, the Bihar, but the election officer, the block development officer, appointed by the Bihar State Election Authority, and the district magistrate is the district election officer, and the district cooperative officer is deputy district election officer, Lordship. It is unheard that the election of the returned candidate has been set aside without an election petition, Lordship.
Oh, if the election was to be held by the election authority,
Lordship,
and if it was not held by the election authority, then such election has no significance, no recognition.
Lordship, that is the point. But the order, Annexure 5 itself is illegal.
You could have challenged that.
I have challenged, Lordship. Otherwise,
you are challenging after the election.
Lordship, nobody was aware about the Annexure 5, Lordship. Fact has been not verified from the district magistrate or the district election authority whether the Annexure 5 was properly communicated or not. Police officers came, observer was there. Even the respondent number 9 has participated in the election and taken calculated risks.
Annexure 5 has been e-gazetted.
Lordship, but nobody was aware of, Lordship. Nobody was aware, Lordship. And even if Lordship...
gazetted, Mr. Counsel, this observation has been made for a definite purpose.
Lordship, the order was communicated to the district officer, police adhikchak, police force came, there was observer.
Everything you managed?
Respondent number also participated in the election, Lordship.
If there was any decision of the election authority, then how could any election be held?
In that case also, Lordship, even during the exercise of the plenary power of the superintendent's direction and control, Lordship, the principle of natural justice is involved. In the Mahendra Singh Gill judgment, Lordship, in the case of repolling, the Mahendra Singh Gill case, the Supreme Court observed that, yes, when the order has a civil consequences, while exercises the action superior control, the principle of natural justice has to follow, Lordship.
All right.
On this score also, order Nexus 4 is also, Lordship, illegal, Lordship. Exhaustive discussion on the issue of natural justice, Lordship. Two restrictions has been given for exercising the superintendence direction. Beyond the statute, the election authority cannot do anything and has to follow the natural justice, Lordship.
So if any election of a parliamentary constituency is held without notification by the Election Commission of India, then he will have to be given an opportunity to show cause.
Lordship, in this case, fact is entirely different. As per the program, Lordship,
fact is clear.
As per the program, election was going on.
As per the program, election was illegally held.
On the basis of the complaint of respondent number 9, Annexure 5 was issued.
Yourself, you have stated in the pleadings that it appears inadvertently the
Lordship,
authorities did not know about the stay.
Lordship,
that is your
because I cannot deny this communication, Lordship.
Therefore, in such pleadings, the Red Court should exercise jurisdiction.
I have
the order is without jurisdiction and illegal.
I have fairly submitted that since the order has been there is
We are appreciating your fairness, but that fairness also has to be considered.
But on fact, Lordship, nobody was aware of this order, of a stay order, Lordship. Even respondent number 9, he himself, he was also participated in the election.
It is not your case that there was no such order. You say inadvertently we could not know.
Nobody was aware, Lordship. Otherwise police force, everybody came, Lordship.
Ignorance is not a plea. Once it is e-gazetted, can you be permitted to say that I don't know? That is the law. You are arguing law of natural justice, then let us hear you on this point also. That once there is a gazette, is it open for you to say that you don't know?
Everybody knows. That is the fact, Lordship. And law is also there. This is Lordship. I am not disputing the communication, but neither the DM, nor the DCO, nor the police officer, nobody came with the election has been stayed.
Therefore, it has been rectified that look, you did not respond.
Annexure 5 itself was without jurisdiction, Lordship. Email se भेजा. For any controversial issue, voter list addition of some name or deletion of some name.
We don't know for any reason. The election was not conducted by the election authority. That's all.
And under the State Election Authority Act, it is the competent authority.
Lordship.
That you cannot dispute.
Lordship, it has a power of judicial superintendent direction control. I am not disputing, Lordship. In Lordship, in several decisions, it has been held that on the last occasion, you cannot withhold the election for any controversial reason. Lordship, I have brought one decision of the Ashok Kumar Lordship, constitutional based decision, because in any election.
Why are you shying away from the democratic process?
No, I am elected, Lordship.
Then you will get elected again.
Again, Lordship, the election will be, this was a future, again the election will be held on the same voter list. And it was also in the last election, Lordship.
So you will get elected again. What is
I have no hesitation to fight the election, Lordship.
Yeah,
therefore, you will succeed again.
My submission with regard to natural justice, Lordship, without jurisdiction, Lordship, and Lordship, if election is to be held, Lordship, then it has to be held at the stage when it was halted, Lordship. It is also well settled. Although I have no decision, but it is in the Rameswar Singh judgment, Lordship, 1983 BLJ, Lordship, page 208, Lordship. It has to be started at the stage it was halted.
Observation we make today, we will not, in any way come in between any consideration of the number of voters or voter list. Why should we observe anything of that kind? There is nothing on the record to show that it has been done for that purpose. He says for aparihare karan, it has to be stated.
I have
You say,
stated,
didn't
Lordship.
know.
On the basis of knowledge, I have
You may
stated.
say what
And
you
in fact,
know.
Pradhikar also has come in his counter, which has been served upon me, the same, some issue of the, with regard to some voters.
That is sufficient. Can anyone preempt that they should not look into these things?
No, voter he cannot decide, the election authority cannot decide the membership issue, Lordship. It is in exclusive jurisdiction, the respondent number 9, Lordship, who was elected secretary for, during his tenure, not challenge the membership of anybody. And the election authority itself, in the summary jurisdiction, cannot decide the membership issue, Lordship. He has to hurt the all affected person, Lordship.
Bihar State Election Authority Act 2008 has been enacted. Creating Bihar State Election Authority akin to the State Election Commission, entrusted with the duty and responsibility of holding elections to cooperative societies and other bodies as mentioned in the preamble of the Act. First off, Section 4 of the Act vests with the election authority power of superintendence, direction and control for conduct of all elections to the bodies including cooperative societies. Stop. The petitioner is a member of Patna Branch AG Cooperative Society Limited Patna, a society registered under the Cooperative Societies Act
1935, Lord.
1935. So stop. He has put to challenge an order dated 18/3/21 issued by the Bihar State Election Authority under the signature of its joint secretary, whereby an election of the cooperative society held on 31/1/2021
Not 30, Lordship. It is a mistake in the impugn order, Lordship.
31/2021 bracketed wrongly mentioned 31/1/2021
Because Annexure 3 is my certificate, 30th, and election program is also.
in the order bracket close to be void ab initio. First off, the petitioner was elected as
Secretary, Lordship.
Elected as secretary of the said cooperative society in the said election held on 31/2021. First off, on perusal of the said order dated 18/3/2021, which has been brought on record by way of Annexure 4 to the writ application, it appears that the same has been passed in the light of an earlier notification dated 25/1/2021 issued by the election authority bracketed Annexure 5, whereby the election of the said Patna branch AG office Housing Cooperative Society was stayed because of unavoidable reasons. First off, next, assailing the impugned Land Council appearing on behalf of the petitioner has submitted that the notification dated 25/1/2021 is per se illegal, as it does not specifically disclose the reason why the election of the society was decided to be stayed. He further contends that the election authority has no jurisdiction to issue notification in the nature of the notification dated 25/1/2021 staying the election process. क्या लिखा?
Further contains that the election authority has no jurisdiction to issue notification in the nature of the notification dated 25/1/2021 staying the election process.
Stop. Assailing the impugned order dated 18/3/2021, he has submitted that the said order is unsustainable, having been passed without giving the petitioner any opportunity of hearing. First off, he has further submitted that the election was that the petitioner was not knowing about issuance of the notification dated 25/1/2021 and even the officials who had participated in the process of election were unaware about the notification staying election of the society issued by the election authority. So stop. Next. We are not convinced with the submission advanced on behalf of the petitioner that the impugned order dated 18/3/2021 suffers from any illegality because previous notification dated 25/1/2021 was not made known to the petitioner and other officials, other concerned officials. First off, it is evident on reading of Annexure 5 that the said notification dated 25/1/2021 was e-gazetted and was communicated to all authorities, including the officials of the state government. First off, next, the petitioner has himself stated in the writ application that the district cooperative officer was unaware of the said stay notification dated 25/1/2021, inadvertently. So stop. It has further been stated that the petitioner learned that the election officer was also not aware of the stay order despite service of stay order dated 25/1/2021 through email in his office, as the concerned staff missed to place the email notice before the election officer. Stop. Next, in view of Section 4 of the Act reads as under. Stop. Apparently, power of superintendence, control, and election
Direction.
superintendence, direction, and control vests in the election authority by virtue of Section 4 of the Act. To stop. In exercise of the said power, admittedly, the notification dated 25/1/2021 was issued. Full stop. Despite the said notification dated 25/1/2021, the election was held on 30/1/2021. Full stop. The said election, in our view, has been rightly held to be void ab initio in the order dated 18/3/2021 passed by the election authority. Full stop. The existence of the said stay order dated 25/1/2021 is not in dispute. Full stop. On the ground that the officials and the petitioners were unaware of the said notification, cannot validate the election held on 30/1/2021 contrary to the order of stay dated 25/1/2021. Stop. For the reasons aforesaid, we do not find that any case of interference is made out by this court in a proceeding under Article 226 of the Constitution of India. Stop. This application is accordingly dismissed.
Last 9 months, fresh election has not been conducted.
Not, Lordship.
Why?
God is in connivance of respondent number 9, Lordship. He was the elected, Lordship. He filed the application. When Lordship, for the sake of argument, Lordship.
What is the problem?
After cancellation of election, certain direction have been issued to the district cooperative officer to comply with. So thereafter, my lord, I could not know. My lord may kindly observe that it may expedite.
We however observe that let the state election authority ensure expeditious election of the cooperative society in question, which in accordance with law
At the stage, Lordship, which was halted because it is well settled law in the Rameswar Singh decision, Lordship. In the Rameswar Singh decision and ultimately, finally, 2012, Lordship, it goes up to Supreme Court. It has halted at that stage, it has to be started, Lordship.
Item number 9, CWJC number 12453 of 21, Alok Kumar Singh versus the State of Bihar. For the petitioner, Mr. Sasibhushan Kumar Mangalam. For the state, Mr. S. Raja Ahmed. Age 5.
Let's
file appeal, Mr.
Let's only 2 orders, my lord, may kindly.
Yes, yes. We remember orders in some of the cases I have passed orders.
7-12 lots. Only one line submission is that the order was passed pursuant to a notice which was not in consonance with paragraph 27(2) of the targeted control order. That is only my submission.
File your appeal. File your
Let's say in December, a coordinate bench has entertained such petitions. 7-12.
We can do that. But we will seek affidavit first and then your reply.
For that, no reply is required. It is bare reading of the provision.
Mr. Mangalam, why the appellate authority? Why should you? Which district is this?
The difficulty, my lord is aware.
Mr. Mangalam, which district is this?
Saran.
Saran. How far is Patna from Saran?
It is.
Why the petitioner should not go to the district magistrate instead of coming to the High
Court? They should have gone there, Lord.
Then
the difficulty is that, Lord, that there the appellate authority doesn't hold court.
We are not seeing any writ application with the allegation that the appeals are not being disposed of. We seldom see such applications that we have filed appeal and the appeal is not being disposed of.
Then there is we believe there is some period prescribed under the control orders.
Within what time the appeals should be disposed of?
Just a minute.
And what do you get? Even if we interfere, what do they get finally?
Plus, it has to be remanded. That is all. Plus, what they will get. Plus, one thing my lord would also appreciate. My lords, while sitting, because after this, there is no other remedy available to them before this court. Plus, what I respectfully submit, that in almost all cases, the allegations are such absurd for which there can be no evidence at all, either for or against. What they say, that since you have not produced any evidence in your defense, therefore your license is cancelled. Plus, it is not that since the allegations are established, therefore it is cancelled. Since you have not, or जो आरोप लगाए जा रहे हैं जो inspection note, inspection book, I may consume my lord some time. There is a statutory inspection book with all the PDS dealers. Whenever inspecting authority goes to the for inspection, they never used to let's say, record their inspection note. After they come back, they used to make lots, if your lordship may permit me, I will say desperate charges, for which लाभुक ने कहा है कि 5 किलो के बदले 4 किलो दिया जाता है, कम अनाज दे के ज्यादा पैसा लिया जाता है, उसका कोई एविडेंस कहीं नहीं है। और उसी ग्राउंड पे हुजूर सारा लाइसेंस कैंसिल हो जाता है, सब कुछ हो जाता है। Let's say the appeal, provision of appeal is there under clause 32, Milord.
Rule 32. Not clause 32. Sub-rule 3. It's 28.
32, 60 days.
30 days.
Any person aggrieved by an order of the licensing authority denying this
Within 30 days of the date
or cancellation of the license
Where are reading?
may appeal to the district order officer within 30 days.
Yes.
And the district magistrate shall, as far as practicable, dispose of the appeal within a period of 60 days.
2006, yes.
2016 order.
16, sorry. Then it is prescribed.
हुजूर अगर ये हो जाए तो हम लोगों को भी कुछ खुशी तो होगी कि कम से कम वहां कुछ लोगों को न्याय तो मिल जाएगा। If the time limit is resorted to, I have no difficulty with that. I will withdraw my petition. But if a direction is issued to them that they should decide the appeal within the time framed by the
Petitioner has put to challenge an order passed by the licensing authority, thereby the petitioner's license under Bihar targeted PDS bracketed control order 2016 has been cancelled by an order dated 1/6/2021. The BTPDS control order 2016 provides for an appeal which the petitioner has not invoked. First off, considering the facts and circumstances, this application is disposed of with a liberty to the petitioner to prefer appeal under clause 32 of the BTPDS control order 2016. So, if he prefers appeal within 2 weeks from today, the appellate authority shall condone the delay in filing the appeal, as the petitioner was pursuing his remedy before this court by filing present writ application. Full stop. It is to be noted that the district magistrate is required under clause 32 of the BTPDS control order 2016 to dispose of the appeal as far as practicable within a period of 60 days. Full stop. The court expects that the appeal is disposed of within the period prescribed under clause 32. 32(3) of BTPDS control order. Stop. It is also worth noticing that clause clause 32 bracketed 6 of the BTPDS control order reads thus. So stop. 6 को quote करो. Stop. Next. It goes without saying that the petitioner shall have liberty to invoke the remedies under various provisions of the Act. Stop. This application stands disposed of with the aforesaid observation and direction.
Item number 21, 6/3, 2:15 p.m. CWJC number 18105 of 21 Dinesh Ram versus the State of Bihar. For the petitioner, Mr. Mani Jaiswal, for the State, Mr. Nitin Sudhir.
My Lord, by the order dated 23/11, my Lord, I was granted to time for the filing of the counter. Till the instruction has not come. I pray for one more instance.
Further time is allowed as sought for on behalf of the respondent State of Bihar for filing counter affidavit.
Obliged, madam. Deeply obliged, madam.
This case on. Yes.
22. CWJC 18194 of 21 Dilip Kumar Singh versus the State of Bihar. For the petitioner, Mr. Mani Jaiswal, Mr. Sanjeev Kumar Mishra. For the State, Mr. A.D5. Mr. Ahmed.
Lordship, I have received the copy of the counter affidavit right now, so kindly may given me time.
The office counter has been filed, my lord, and this matter has been supplied copy.
It is stated at the bar that a counter affidavit has been filed in this case on behalf of the State of Bihar in compliance of this court's order dated 23/11/2021. The said counter affidavit is not there on record. Stop. List this case on 2nd week of January.
Gotcha.
Along with the counter affidavit.
Item number 3. CWJC number 1246. 4 of 21, Sudhir Kumar versus the State of Bihar. For the petitioner, Mr. Kumar Kaushik.
Your Lordship, the learned who are appearing in the matter is on his legs in another court. If it may be kindly put up tomorrow, Your Lordship.
As requested on behalf of the petitioner, list this matter tomorrow.
Item 11, CWJC number 13559 of 21, Naval Kishore Sudekha versus the State of Bihar.
May,
For the petitioner, Mr. Mahasudha
may I please your lordship put up after vacation, my lordship. My senior बीमार है, बुखार वगैरह है.
As requested on behalf of
In
the
this case, my
petitioner,
lord,
list this matter.
of course I don't want to object, but the matter is, my lord, the petitioner has come against a so-called notice.
What can be done? The matter was earlier heard. No. All right. Let it come up.
Obliged.
12. CWJC number 13894 of 21, Vibha Kumari versus the State Bank of India. For the petitioner, Mr. Sunil Kumar. For the other side, Mr. Guru Bihari Singh, Mr. Sanjeev Kumar.
May I please, Lordship. This case is regarding the bank loan. My Lord, petitioner was taken
a sum of rupees 5,75,000 from the respondent bank in the year 2010. And since then, the bank has fixed her amount 5,500 per month, and accordingly they deducted the said amount from her account, and all of a sudden in the 2021 bank asked her that your installment should be 7,800 and you have submitted lesser amount, so some amount will be deducted from account. Her account has been kept on hold and deducted.
Please come to paragraph. The amount you had taken was 57 lakh 5,000.
No. 5,75,000.
5 lakh 75.
My lord. हुजूर 144 महीने 12 साल के लिए अमाउंट था होम लोन का, और लगभग 10 साल 11 साल कटा है, और एकाएक ये कह रहे हैं कि आपका अमाउंट जो है लेसर कटा है, और बिना कुछ कहे इन्होंने हमारे अकाउंट को होल्ड पे रख दिया, और जो अमाउंट मेरे अकाउंट में था सब डिडक्ट कर लिया। और अब स्थिति हुजूर ये है कि किसी महीने में 27,000 काटते हैं, किसी में 39 काट, कोई फिक्स अमाउंट नहीं काट रहे हैं, और हमारे साथ हुजूर अब लाइवलीहुड का समस्या आ गया है। I have annexed Annexure 1, the loan account statement. हुजूर Annexure 2 है, जो इन्होंने हमको कॉल किया और हमसे कहा कि ये है, और इन्होंने जो लिखवाया है उसमें हमने एडमिट किया है कि यदि आपका अमाउंट बचता है किसी कारण से तो हम 25,000 के इंस्टॉलमेंट में आपको दे देंगे, लेकिन इस तरह अनसर्टेन अमाउंट देने में सक्षम नहीं है। लेकिन यदि बचता है, हुजूर हमारे पार्ट से कोई कमी नहीं हुई है, इन्होंने 10 साल कंटिन्यू काटा है विदाउट एनी कंप्लेन।
You have any instructions?
My lord, in this case, 4 weeks time for filing counter affidavit. In this matter, my lord, the petitioner entered into agreement with the bank, my lord, and fixed the installment of rupees 7,800 and signed by the petitioner, my lord. After that, petitioner only pay rupees 5,500 in as per the he pay rupees 55,000, my lord.
Where is the agreement?
हुजूर हम हुजूर क्या मेंशन किए थे उस समय, हुजूर मांगे थे कि एग्रीमेंट लाइए। मैं बैंक को रिप्रेजेंट किया, आवेदन दिया कि हमें एग्रीमेंट दीजिए। उन्होंने कहा कि यदि कोर्ट मांगेगी तो मैं दूंगा।
Come with the agreement.
My lord,
What is your liability under the agreement? You don't know.
हुजूर सामान्य व्यवस्था है तो हुजूर भी अवगत हैं कि क्या होता है। सीधा साइन किया है, लोन लिया, अपना घर बनाया।
And if you have agreed to such a kind of transaction, then you suffer the consequence.
हुजूर हम कैसे, ये 10 साल तो इन्होंने काटा है।
How do we know what is your liability? We are not going to go into account.
हुजूर वहां तक ठीक है, लेकिन मैं काइंडली अप्रिशिएट मी, इन्होंने 10 साल तक कंटिन्यू कोई हम पर
They have issued a legal
तो
notice to you. Have you responded?
ये हुजूर 2021 में हुआ ये।
Have you responded to the legal notice?
नहीं।
Then you go and respond. They will consider. Where is the occasion for this court?
हुजूर इसमें हमारा कोई गलती तो है नहीं, ये 10 साल तक गलती करें, इसके सजा हम भुगते हैं।
And we can't determine who is at fault.
Where is your legal notice?
ये Annexure 5 at Annexure 20 at page 27। हुजूर ये कहते हैं पारा 6 में कि यह की ऋण राशि की अदायगी हेतु कई बार शाखा प्रबंधक भारतीय स्टेट बैंक मुख्य शाखा अररिया जिला अररिया से मौखिक एवं लिखित रूप से अनुरोध किया गया। हुजूर इस नोटिस के पहले एक नोटिस यदि दिखा देंगे तो हुजूर जो कहेंगे हम मानने के लिए बाध्य हैं।
petitioner has filed this writ application seeking direction, writ application for restraining the respondent State Bank from making deduction from the petitioner's account against loan advanced to the petitioner to the tune of rupees 5,75,000. Stop. It is the petitioner's case that in terms of loan agreement, the petitioner was required to pay a sum of rupees 5,500 per month by way of installment for 12 years, which she was paying. Stop. It is her grievance that suddenly the bank has started making deduction of a sum of rupees 30,648 per month from the petitioner's account for the next 21 months on the ground that the petitioner was required to pay a sum of rupees 7,800 per month instead of sum of rupees 5,500 by way of installment. Stop. Next, the petitioner has not brought on record the home loan agreement. Stop. The petitioner has been put to legal notice by the State Bank on behalf of the State Bank through letter dated 5/7/2021. The petitioner has admittedly not responded to the said notice. It appears that it's a pure question of accounting for which the petitioner could have approached the bank and could have taken any other remedy as available to him under the law. Stop. We are not inclined to entertain this writ application under Article 226 of the Constitution of India. This application is accordingly dismissed. Yes.
Case number 17945 of 21, Nijama Khan Kumar Verma versus the State of Bihar, to the petitioner Mr. Jitin Kumar plus Subodh Kumar Srivastava.
My lord, in this case, petitioner, this case is for direction to the respondent Patna Nagar Nigam, Patna Municipal Corporation, to grant water connection to the petitioner who is living in Rajendra Nagar, Patna Nagar Nigam flat. My lord, as per Annexure 1, a lease deed was made for 35 years in favor of the petitioner by the LOT of the flat. My lord, the Bijli connection is in the name of the petitioner, but the person who is living at the ground floor, who is disturbing my water connection, my everything. I submitted application to the Patna Nagar Nigam to connect my house from the water supply. Patna Nagar Nigam processing or process for inquiry, you gotta pass the order for water connection. When the staff of the Patna Nagar Nigam went to connect the water connection, the police came and prevented the water connection, not to connect the same. In the collision with the person Rakesh Ranjan, who is living in the ground floor of that flat. My lord, Rakesh Ranjan has also filed eviction suit in the civil court before the subject Patna.
That is his house.
My
Flat in which you are residing belongs to him.
Belong to the lesser who had अमरनाथ लाल करके हैं, जो अनेक्सर 1 में उनका नाम है. ये कुछ नहीं है, ये वहाँ रहते हैं नीचे ई ग्राउंड फ्लोर में एज ए रेंटर रहते हैं ग्राउंड फ्लोर में. ये हमेशा डिस्टर्ब करते रहते हैं कि यहाँ से किसी तरह इनको भगा दें. बस दिस इज द केस माय लॉर्ड. माय सबमिशन इज at least he has filed the eviction suit admittedly.
Who has filed?
My lord.
Who has filed eviction suit?
Who has filed eviction suit? With ground floor, the person who is living in the ground floor named as Rakesh Ranjan.
So he has filed because he is the landlord.
No, he is not the landlord.
Then?
Landlord is the राकेश रंजन. हम लोग को कौन दिए हुए हैं? हम लोग को जो दिए हुए है हाँ, असली जो है वो है अमरेंद्र लाल राय.
So you are disputing his title over your flat.
I am also disputing his title, or my humble submission is at least till the eviction suit is not cleared, is not finalized, my water connection allowed to be continued.
This is a private dispute between you.
कि ये एसेंशियल कमोडिटी है. मेरा 35 साल का हुजूर ये लीज डीड है बना हुआ 240 तक का लेसर के द्वारा. तो वैसी हालत में हम रह रहे हैं.
You are living there since when?
My lord.
Since when you are living in that flat? Since when you are living in that flat?
My lord, I am living 2005 से.
When did you apply for water connection?
उधर तो जो चल रहा था ठीक था. कब किया? 2020 में. उधर ठीक ठाक था, इधर डिस्टर्ब करना शुरू कर दिया.
You have leasehold rights.
My lord.
You have leasehold rights.
My lord.
Then
Yes.
what is the remedy for amenities? You have to move the subdivisional officer. Why have you come to the High Court?
My lord, the only submission is
This
the
is essentially
water
your
is
requirement of amenities.
my lord,
For
my
that
lord,
there
water
a
is
special
essential
statute.
commodity.
That is why there is a provision. Why have you come to the High Court?
Direction SDO को.
Why? Without your approaching the SDO, a direction should be issued. You file your case before the subdivisional officer for amenities.
For the?
I am not here to advise you, Mr. Counsel.
You have not given us the advisory jurisdiction, Mr. Counsel.
My lord, I filed application to the district magistrate,
All right.
to the district magistrate, to the
See,
DGP.
either you were to file an application before the competent authority under the Apartment Ownership Act or for amenities before the SDO. Neither of the two remedies you have availed. You are rushing to the High Court with this, that on basis of this lease deed I should get everything.
My lord, in the meantime, at least his case is decided. My water connection may be allowed.
All right. Heard learned counsel for the petitioner and learned counsel representing the respondents.
Patna Municipal Corporation.
The petitioner is seeking a direction to respondents number 4, 5 and 6, 4, 5, 6, 7 and 9 for granting connection of non-domestic water supply. Water supply in the petitioner's flat located at Rajendra Nagar. Full stop. From the submissions advanced on behalf of the petitioner, it appears that the petitioner is a tenant in the said flat, in respect of which an eviction suit has been filed by someone. Full stop. Learned counsel for the petitioner has argued that the person who resides in the ground floor of the building is causing obstruction in permitting in grant of connection of water supply. Full stop. Next. The petitioner, in our opinion, has a remedy before appropriate executive authorities and not executive authorities without invoking which he has approached this court. First off, there being alternative and more efficacious remedy, we are not inclined to entertain this writ application. This writ application is accordingly dismissed. Connection.
CWC number 17983 of 21, Anuradha Tiwari versus the state of Bihar, for the petitioner Mr. Ashwini Kumar Dubey, for the state Mr. Kinshor Kumar.
There is no representation on behalf of the petitioner. Learned counsel for the respondents is present. Let's this case on tomorrow.
50, CWC number 18717 of 21, Rajneeshwar versus the state of Bihar, for the petitioner Mr. Nityanand, for the state Mr. Pawan Kumar.
May please, Lordship. This is an application for quashing the entire tender proceeding on the ground, my lord, that the single bid has been approved by the authority. Only the ground. And representation was given to the authority, but sitting tight over the matter till the death, my lord. And as per provision contemplated under Rule 31, at least minimum 3 bidders should be participated, my lord. My lord, although it is, my lord, first tender notice was issued on 21st January 2001, and the same process was some person has participated, but all tender was rejected on the ground that this is not accordance with the law, आप कहते हैं कि 15% मार्केट वैल्यू से जो भी सप्लाई आर्टिकल होगा उसका 15% कम या ज़्यादा हो सकता है, वैसा नहीं था इसलिए एंड ऑन दिस वाज रिजेक्टेड ऑन 6/4/2021 मीटिंग एंड with the statement that a further notice be issued. Thereafter, my lord, after 4 months, second tender was issued. In the second tender, my lord, 2% has been participated. Out of 2%, one tender was rejected on technical ground. And second person was approved, my lord, financially approved, my lord. And with respect to my lord, Rosra Jail, my lord, 3% and we participated, filed, but give some, submitted that tender, my lord. Out of 3%, 2 tender were rejected on technical ground, my lord, and 1 was approved, my lord. So, my submission, my lord, at least, as per provision, 3 tenders should be considered, my lord. As per rule, I of the Bihar financial rule, my lord, that is, my lord, is said also annexed with the petition, my lord, and 31I say
Yes.
that is running page 41, my lord. 31I rule has been also annexed with the petition, my lord. This method, limited tender inquiry. This method may be adopted when the estimate value of the good.
When was the first tender notice issued?
My lord?
When was the first tender notice issued?
First tender notice was issued, my lord, on 21st January 2001, my lord. 21, my lord, sorry.
Then and this happened?
Thereafter, the same was in this meeting dated 6 April 21. This the whole tender was rejected on technical ground कि टेंडर जो में वैल्यू जो दिया गया था मार्केट वैल्यू से नियम के अनुसार 15% से ज़्यादा और 15% से अधिक नहीं होना चाहिए. मार्केट वैल्यू से या तो 15% से कम नहीं होना चाहिए और 15% से ज़्यादा भी नहीं होना चाहिए. Thereafter, my lord, second tender notice after 4 months was published, my lord.
When?
In that second notice, my lord.
When was
that
published?
That was published, my lord, on 5/8/2021, my lord. Then, my lord, in pursuant to the second notice, my lord, 2 persons submitted their tender notice with respect to I have stated in para 11, my lord, that pursuant to the tender notice, only 2 persons, namely Messrs. Hassan Tedder and Grish Kumar, submitted their tender for supply of the grain article mentioned in
2 persons submitted tender.
My lord.
Did you submit your tender?
My lord, I was not submit. I am not participated, but earlier I was participated in first tender notice, my lord.
Why did you not participate in the second tender? And then what right do you have?
Of course, my lord, but the person who participated in notice also gave the representation to the authority. A joint representation was given, my lord, that is Annexure 5 to my petition, my lord.
But you are not aggrieved, you should not be aggrieved. Otherwise, everywhere where single tender has been allowed,
My lord, due to certain reason I could not participated at that time. The father of the petitioner died, my lord, and on that ground. But, my lord, accepting the single tender is in violation of
the petitioner seeks quashing of the entire tender process arising out of tender notice dated 5/8/2021 issued by the superintendent, district jail Muzaffarpur for supply of grain and other articles.
अगर हुजूर की इजाजत हो तो एक बात खाली करना, हमारा रिपनसेशन डिस्पोजल का भी अगर ऑर्डर कर दिया जाता।
The sub jails Rosra and Dalsing Sarai. So stop. Next, this is an admitted position that the petitioner did not submit his tender in response to the tender notice dated, said tender notice dated 5/8/2021. So stop. In such circumstance, in our view, the petitioner cannot maintain any grievance against the tender process in which he had not participated. So stop. We do not find any merit in this application, which is accordingly dismissed.
CWC number 18734 of 21. Arvind Paswan versus the state of Bihar for the petition for the state which is able to draft the
Let's say, though I had a case, but there is some difficulty with me. Let's say the petitioner was the chief councillor of a municipality. There was a requisition against him by requisite number of ward councillors for bringing a no confidence motion. So the first requisition was submitted by them on 16 on 27/9/2021.
27/9?
Annexure 1.
27/9?
2021.
21?
My lords.
First?
First.
Then?
This was, apart from other things, this was not even addressed to the petitioner, rather it was addressed to the executive officer. सेवा में श्रीमान मुख्य कार्यपालक पदाधिकारी. It was not acted upon for the reason that some signatory of this requisition they had given in writing that our signature on the requisition has been fabricated. Then the next requisition was submitted on 29/9/2021. That's it in Annexure 3 at page 25.
Yes.
However, this was again addressed to the Kaljpalak Pradhikari.
Yes.
And therefore, Lords, it was not in tune with the statutory provisions contained in Rule 2.1 of the Bihar No Confidence Motion Process Rules 2010.
Yes. Yes.
Lords, even if it was not addressed, and it was never, Lords, given to the petitioner, it was directly filed in the office of the executive officer. But since it was received by the petitioner through, Lords, the executive officer, he had asked the executive officer to seek some guidelines from the department. But instead of doing that, Lords, since the requisitionists themselves fixed the date of a special meeting, Lords, on 23/10/2021.
Yes.
Lords, Annexure 6, page 32 is the notice issued by the executive officer.
Yes.
Lords, the writ petition was initially filed challenging this notice But with the pendency of the petition, says the matter could not be taken up, therefore IA number 1 of 2021 was filed, bringing on record the resolution in the special meeting dated 23/10, and prayer has been made for its passing. Lords, so far statutory provisions are concerned, Lords, they are clear, Lords, that for that a request has to be made from the Chief Councillor itself. Of course, Lords, if the Chief Councillor, despite receipt of request, if it doesn't fix a date of a special meeting, then Lords, ward councillors, they have been conferred power under Rule 2(3) for fixing the date of a special meeting. But here it was a case that the requisition itself was addressed to the executive officer, and therefore this was not a valid requisition in the eye of law.
That is the only point.
That is my only point. But my difficulty is there in the special meeting itself. The petitioner has participated.
And why are you unnecessarily?
हुजूर, अब हुजूर का कोर्ट का प्रोसीडिंग हुजूर.
The petitioner originally sought for quashing of the requisition of no confidence motion.
That's one thing, Lords, if my Lord may kindly consider, Lords. In the meeting also, there were dispute over the validity of the votes. The petitioner had raised the objection in the meeting itself that there are certain votes which are invalid, and if they are taken out of the number of valid votes, the requisition, the motion has to fail. But the grievance has been made in the IA application that since it was not considered, it was neither even recorded in the proceeding. And because the person, the deputy chief councillor who was presiding over the meeting, he was also instrumental to bring all these things. Therefore, if a direction is given to any competent authority, Lords,
Why competent authority?
for verification of only that part, Lords,
This writ application was filed originally seeking quashing of a requisition of no confidence motion, and consequential notice dated 16/10/2021, against the petitioner who held the post of chairman,
chief councillor,
chief councillor, Nagar Parshad Lakhisarai. Stop. Subsequent to filing of the present writ application, admittedly, a special meeting was convened in which the no confidence motion was brought against the petitioner. Stop. The said no confidence motion has been passed, and accordingly the petitioner has been removed from the post of the chief councillor. Stop. The said action of the petitioner's removal on the basis of a removal consequent upon passing of no confidence motion is sought to be challenged by seeking amendment in the writ application through IA number 2, IA number 1 of 2021. So stop. Next. Mr. Mangalam, learned counsel, appearing on behalf of the petitioner, has submitted that the requisition was addressed to the executive officer of Nagar Parishad Lakhisarai, which ought to have been addressed to the petitioner, and therefore a requisition itself being bad, consequence, no confidence motion passed against the petitioner cannot be sustained. Full stop. Next. Be that as it may, this is an admitted fact that the said no confidence motion was placed before the petitioner by the executive officer, and the petitioner did in fact participate in the special meeting in which no confidence motion was brought against him. Stop. In such circumstance, we do not find any illegality in petitioner's removal from the post of chief counselor consequent upon passing of the no confidence motion. Stop. The writ application, comma, in our opinion has no merit and is accordingly dismissed. All interlocutory applications stand disposed.
My Lord, in this case, my Lord, petitioner, my Lord, participated in Bihar general election, my Lord, for Panchayat, my Lord.
File election petition, why have you come here?
My Lord, certain facts is required to be considered before your Lordship, my Lord. By the annexure 2, my Lord, petitioner was allotted, my Lord, symbol, my Lord.
You can raise all these pleas before the tribunal, not before the court. High Court cannot decide. High Court cannot decide.
This is not the remedy.
उसमें हुजूर एक लिमिटेशन क्या होगा? लिमिटेशन यहाँ तो हम हुजूर के यहाँ आ गए हैं within 30 days.
No, limitation they will decide.
Lords.
Whether limitation, the petitioner has put to challenge election of Gram Panchayat of citizen. The petitioner has put to challenge Gram Panchayat election of Naya Bhargama Gram Panchayat in the district of Araria. Stop. In our considered opinion, the petitioner has a remedy of preferring election petition if otherwise eligible, before appropriate forum. This writ application under Article 226 of the Constitution of India, seeking nature of relief as sought in the present application, cannot be entertained. This application is accordingly dismissed.
Limitation,
we don't know whether the limitation can be condoned or not. That is whether
हुजूर के यहाँ तो हम आ गए हैं within 30 days.
के आने से नहीं होता है. Limitation can limitation be condoned for filing suit? Can a limitation?
वो तो डिसाइड होगा वहीं पर ही, इशू तो डिसाइड होगा वहीं पर ही, लेकिन एक लाइन लिखने से.
You can take that. You can take that.
But the petitioner was the chief councillor of Muzaffarpur Municipal Corporation. But a requisition was circulated by the ward councillors for bringing no confidence motion against him on 12/7/2021. Some dates are relevant. The first requisition was brought in loss on 12/7/2020. Months.
Yes.
Months. 12/7/2021.
Yes.
And pursuant to this, Milords, a notice was issued, Milords, in Annexure 2 for holding the special meeting on 24/7/2021.
Yes.
Now, Milords, on 24/7/2021, the resolution was carried out against the petitioner and therefore he was removed from the post. And this resolution, Milords, was subject matter of challenge before the Honorable Court at the instance of the petitioner. Milords, in CWJC number 16,240 of 2021.
15,000?
16,240 of 2021.
Yes.
Now, Milords, after this special meeting, when the vacancy was
You have
reported.
filed 16,200.
Yes, Milords.
Are you sure, or you have filed 13399?
133. I'm sorry. No, 13399 is by Nand Kumar. I'm sorry, Lord. Yes, 13399. I'm sorry, Lord. I just stand corrected, Lord.
And they have filed for implementing
My
the
lords.
result of the special meeting.
My lords.
That is the other case.
My lords. I'm sorry. I'm obliged, lords. Now, lords, when the matter was reported to the State Election Commission for the purposes of fixing the date of election, lords, the State Election Commission noticed certain flaws in the proceeding. And therefore, ultimately, it refused, my lords, to fix any date for the purposes of election. Now, lords, in the meantime, a writ petition was heard by this Honorable Court in respect of Los Kochas Nagar Panchayat.
This
Now,
is which panchayat?
Lord, this is Muzaffarpur Municipal Corporation. Now, in that writ petition, Lord, a bench of this Honorable Court had since found that the meeting was convened in violation of Section 49 of the Act, since there was no 72 hours notice to all the councillors. Therefore, the special meeting, the decision in the special meeting was quashed with the liberty given to the ward councillors to bring a fresh no confidence motion. Lords, I had challenged my removal in my writ petition. Now, while the writ petition was pending before the Honorable Court, there being without any order and without any authority, the matter was taken up by the state government itself. And the state government, while it's later contained in, let's annexure 5 at page 28. The state government came to the conclusion that since it was not a valid no confidence motion, therefore the petitioner is stood restored to the post. Lords, in my respectful submission, though it is in my favor, but there was no such authority, Lords, to the state government under the law. But it was for some oblique purpose, Lords. Since they were finding it difficult to choose a chief councillor because the State Election Commission was not prepared to fix the date of a special meeting. Now this order is dated page in Excel 5, page 28. My lord, may kindly.
Mr. Mangalam,
My lords.
a no confidence motion was carried out against you.
My lords.
But by virtue of that, you stood removed. Now that decision has been found to be illegal by this court.
No, lords. This court had decided a case of some other Nagar Panchayat.
Not this.
Not this case, lords. The state government took the matter on its own and had, in Excel 5, my lord, may kindly see page 28. Relying upon the judgment of this court in Kochas Nagar Panchayat case, the state government has comes to a conclusion passed against the petition was since not a valid no confidence motion. Therefore, the writ petitioner is restored to the post. However,
You want to be ousted.
no, Lords, what I am respectfully submitting, Lords, that the matter was pending here, and there was no authority to the state government. But purposely this letter was issued by the state government interfering with that, so that a fresh no confidence may be brought against, and the petitioner may again be removed so that there has to be some election.
Yes.
Plus the proximity of the events thereafter would demonstrate, Lords, that this was arbitrary exercise of power with certain other purpose. Plus 810 is the letter of the state.
Mr. Mangalam, you want to remain ousted.
No, Lords, I am coming to that, Lords.
Yes, you were removed.
My Lords,
So you
now
want-
810 I was directed to be reinstated.
Yes.
This state government decision is 810. Now this letter of the state government is not marked to me. Now after receipt of this letter on 9/10/2021, if my Lord may kindly turn to page 30 in extra sec.
Let us presume that this communication is illegal.
Let's, just in the event sequence of events, I have referred to this. Let's, my anxiety is somewhere else.
Yes.
Let's, this is the decision of the state government dated 810. On 9/10, the municipal commissioner issues a copy of this letter to all the ward councillors. And on 11/10, a fresh requisition is received by him. Now, pursuant to 11/10 requisition, even though I had not resumed the charge of my office, this letter was not served upon me, the state government letter. Even the commissioner's letter was not served upon me. However, a requisition was again received by the municipal commissioner in his office, bringing a no confidence motion against me once again. It was on 11/10. Now, Lords, this was not given to me, Lords. And in pursuance of that, since it was never brought to my notice even by the municipal commissioner, since I had not assumed the charge after 8/10, Lords, I was out of a station, I have mentioned in my petition. I came back on 12. And after made a specific averments in my petition that from 13 and onwards, nobody had come to me, Lords, for giving the copy of this requisition. And after that, Lords, a date was again fixed by the requisitionists themselves. And pursuant to that, Lords, the notice was issued by the Lords, municipal commissioner, which is in Annexure 8, page 35. Submission for my Lord's consideration is that after my removal and my reinstatement on 8/10.
No, Mr. Mangalam, under which jurisdiction this notice was issued, this letter was issued by the state government?
That letter is also under challenge before. Therefore, I have said.
Therefore, Mr. Mangalam, every action taken after this P5 is illegal.
My Lords.
All action before that is valid.
My Lords, if that is so, Lords, my writ petition, I will argue my first writ petition. That is my Lord's anxiety. That it was arbitrary, Lords, exercised by the state government.
Where is that? Where is the other writ petition?
My Lords, it is before my Lords.
Is that listed?
It is at serial number 934, Lords.
934, then all the matters will be heard together.
How much? My Lord,
2 matters or 3 matters?
Plus one matter,
How many matters
probably
are there?
not.
All three matters have been filed by the present petitioner, and apart from that,
No,
one matter
only
has
two
been
matters.
filed by the same learned AOR on behalf of Mohammad Javed Akhtar, wherein the order passed by the state government dated 8/10/21 that is under challenge, in which the present petitioner is the respondent number 5.
So whether those cases are before this bench?
My lords, the case in which the order of the state government is under challenge, my lords, that is before this honorable bench, my lords, that is at serial number 934. So far as the other two cases are concerned,
Lord, so far, I'm giving Lord, so far 12761 of 2021 is
You are
concerned.
making submissions against annexure P by 5.
My lords.
You have not assailed P by 5.
No, Lord, I have not, but that is under challenge.
Where is that under
Lord,
challenge?
Lord, that is under challenge in CWJC, Lord.
18811 of 21.
That is filed by?
That has been
Some
filed by
other
the same
person.
learned AOR, my
No,
lords.
Some other person. I have filed it, Lord.
We are not concerned. This petitioner has not assailed that. So
Naturally,
what is
Lord,
the
sir.
reason? What is the reason for having?
Lord, my submission is that all subsequent actions after annexure P5
We'll see.
are illegal.
All right.
Since it is itself illegal, Lords. P5 itself is, Lords, without jurisdiction.
You can't argue so. That is not your case. Maybe the counsel may be the same in both cases, but he can't argue the same point in every petitioner's case. Petitioner you are representing today in respect of whom you have to make submissions.
Lords, therefore, I have not challenged, Lords, annexure 5. That is correct, Lord. What I respectfully submit, that since the order annexure 5 is illegal, Lords,
How can you say that?
You can't say that.
When you have not challenged this order, then how can you say that this order is illegal? You have accepted this order.
Lord, since I had to accept this order, Lords,
And since you are not assailing this, can you, the same counsel, now have a
Lords,
different stand
Lords,
in another case?
Lords, I'm not challenging, Lords. I'm sorry, Lords.
Mr. Mangalam, you are not sure what stand you should take
Lords,
in
my
which case.
my submission is, Lords, that after annexure 5, Lords, Lords, I'm conscious I have not challenged annexure 5. After annexure 5, my reinstatement, Lords. Now, Lords, the procedure which has been again adopted for my removal, Lords, in my respectful submission, they are arbitrary, Lords. Lords, the municipal commissioner is not competent under the law to receive any.
All the 4 matters should be heard together?
Yes,
What are they? What number?
CWJC number 12761 of 2000.
CWJC number 127.
12761 of 2021.
Yes.
That is at serial number 565 on the in the consolidated list.
Yes.
Thereafter, CWJC number 13399 of 2021. That is at serial number 582.
Yes.
Then we got CWJC number 18811 of 2021. That is at serial number 934.
So all the 3 cases are before this bench. List this matter along with CWJC number 12761 of 2021, 13399 of 2021 and 18811 of 2021 on when do you want?
As per my Lord's convenience.
Yes, yes. Second week of January. In which case you are not appearing out of 4 cases?
But I'm not appearing. Lords, it is. No. Lords, I'm not appearing in CWJC number, my Lords, 13399. Perhaps this has been, Lords, I'm sorry, 16240. Perhaps this has been withdrawn by the After the state government order, the ward councillor who had come for implementation of the proceeding of the special meeting, now he has withdrawn it. Therefore, in all cases, I am appealing.
That has been disposed, my lords. That matter is not pending.
Which matter?
The matter which is referring to
16240.
My lords, 16240. It has been withdrawn.
That is over.
I am appealing, lords, in all cases.
In all the cases.
No.
All right.
There are 3 cases.
4 cases.
4 cases.
including this one.
Well, so far one case, well, so far 12761 is concerned, this has no bearing so far the present issue is concerned. Therefore, this is not required to be heard along with this, because in this case, Lords,
So what is that about?
the prayer is that since the state government has amended the Gram Panchayat Act, so far no confidence motion is concerned, and it has been said that now only once the no confidence motion can be brought against the elected chairpersons. Now the grievance is that since for the purposes of stability, some protection has been granted to the elected bodies of the state under the panchayat. Therefore, the same protection should be given to the municipality also. Therefore, 12761 is not required to be heard along
No,
with.
but the hearing of that matter is going to be expedited. What?
No, I have no difficulty. I have no difficulty.
You are appearing in that case also.
I'm sorry. Yes, no.
All right. वो उसको हटा दो. 12761 को हटा दो.
Much obliged. Lords, may I pray that in the meantime, if you are so inclined, notices will go to not the private
Let
respondents.
the matter come first. Let the matters be heard first.
हुजूर यही मैटर आया था, हमने इलेक्शन स्टे का प्रेयर किया था, but unfortunately since it was not printed in my lord's consolidated list, though the matter was listed, but
Yes, we remember.
कुछ पहले हुजूर कर दिया जाता.
In January is the
Second week, my lord.
Second week of January.
Number 19309 of 51, Sinika Devi versus the State of Bihar, for the petition Mr. Ram Pravesh Nath Tiwari, for the state of Delhi, 8-5.
May.
Yes. Mukhiya of Gram Panchayat.
My lord,
Then you file for the election authority or file.
my lord, election authority I have moved.
Then?
But my lord, no order is being passed, my lord. That not I have stated also in my petition. And my lord, she is ineligible because
Where have you filed?
Lord, I have filed. Lord, I have got a copy also.
No, no. Where have you annexed?
2 months back. I have given Lord on 1/11/2021. 1/11/2021.
We cannot entertain this.
Lord, may I pray one thing, Your Lordship, Lord. Since, my Lord, we have moved there, he is, my Lord, because the Mukhiya is, my Lord, ineligible. She has not attained the age of 21 years. She has not only, my Lord, shown the false affidavit, rather, my Lord, in view of the statutory provisions.
You have remedy for the election.
Yes, my Lord, I have, my Lord, though, my Lord, the alternative remedy is, my Lord, as Your Lordship has held, my Lord, several times, that is not absolute, but we are, I am not, my Lord, against that, my Lord, if election commission, my Lord, decides that matter, my Lord, may I pray a time frame may kindly be, my Lord.
Time frame, we have not even annexed the.
My Lord, I have given a statement, my Lord, that has not been annexed, my Lord, but I have given a statement, my Lord.
We can just observe that your application, your representations have been considered expeditiously. Had the representation been there before us, we could have made certain observations.
Lord, the receiving is there, Lord, and I have got a copy, Lord. Only a time frame, Lord, and Lord, since Lord, she will exercise the power, though being ineligible and all the actions, Lord. So therefore, Lord, a time frame will be.
Which provision is there under the Act?
136(2), my lord. 136(2).
136(2). the petitioner is seeking direction to the respondents to disqualify respondent number 5 to hold the post of Mukhiya of Gram Panchayat Kajpa in the district of Aurangabad on the ground that she had not attained the requisite age of 21 years as on the date of her election. Next, the 136(2).
Clause 2.
She has sworn the false affidavit also regarding educational qualification.
The petitioner and senior counsel appearing on behalf of the petitioner has submitted that the said respondent number 5 has sworn a false affidavit at the time of filing of her nomination papers in respect of her educational qualification.
Age as well as educational qualification
Age
both.
as well as educational qualification. First of all, be that as it may, comma, the petitioner has statutory remedy under section 136 bracketed 2 of the Bihar Panchayat Raj Act 2006. First off, it is being submitted that the petitioner has already approached the State Election Commission.
Yes, Lord.
By making a representation. First off, no such representation is, however, there on record. First off, where is your statement?
Lord, that paragraph number 16, my Lord, page number 8.
It has been, that is quite vague. Though it has been stated that the petitioner has filed representation before the State Election Commissioner, comma, in paragraph 16. So, be that as it may, considering the provision under section 136 bracketed 2 of the Act, this application is disposed of with a liberty to the petitioner to pursue his remedy before State Election Commission. First off, since the plea of disqualification of an elected person is being taken, comma, the court expects that the Election Commission shall expedite decision in this regard.
May I pray one more thing, my Lord, regarding, my Lord, some interim order, my Lord, I will move there, my Lord, regarding, so that if your Lordship will observe,
Unless
Lord,
you
for.
move your representation, when your representation is not here, you move anything.
My Lord, I have got a copy of the
Therefore,
receiving is also there.
After, my lord, after hearing that is point number 5, my lord.
Huh?
After hearing that is point number 5.
After
hearing the private point number.
May I pray one more thing, Lord, since he is here, and this question of eligibility, my Lord, a date may kindly fix, my Lord, we both will appear there, Lord, if, my Lord, my Lord.
we don't know, your representation is not here before us.
My Lord, that is not the
Can't
fault
go
on my
on
part,
with
my
an
Lord,
order
but.
of the High Court in such matters. It is for them to decide what they will do.
Go there first. Yes.
नहीं अब तो ऑर्डर कर देता बोलते
क्या बन गया चलो May please, my lord. My lords, I am aggrieved by annexure 3, page 18, if my lord would kindly look into. My lords, the simple issue which arises out of this writ application is, my lord, page 18, my lords, annexure 3. May I, my lords? My lord, the simple issue which arises that a panchayat, my lord, which has been mentioned in column 4, has been upgraded, my lord, to Nagar Parishad Kasba, which could not have been done, my lords, because this has been now attached with Nagar Panchayat Kasba and it has been upgraded to Nagar Parishad Kasba. My simple submission, my lord, My submission would be here, my lord, that this is an illegal order, my lords, on the face of it, for the reason, because in view of the constitution, my lord, and the municipality as envisaged in the constitution, my lord, there is a transition period. My lord, at the outset I am submitting this, that there is a transition period for any panchayat or any my lords, nagar panchayat to be, my lords, first of all, the panchayat has to be in a transition period, only thereafter the upgradation could have been done. Now, my lords, the second, I will go through it, my lord, in detail. The second objection is also with respect to the fact that
No,
is
what is
annexure.
that? Where is that transition period?
My lords, it is mentioned in the constitution, my lord, 243Q, my lord will kindly see. Lords, after the 73rd, 74th amendment, lords, the panchayat in part 9 and then part 9A. If my lord will kindly see, my lord, 243Q of the
what
constitution.
problem do you have?
Lords,
Gram
my
Panchayat,
difficulty is,
these villages, 4 villages have been included in Nagar Parishad Kasba.
No, my lord.
You
Yes.
have grievance against this.
Yes, my lord.
Now, how this 243Q comes into play?
My lords, in fact, this was my objection. Now, my lord, when I go through the constitution, my lord, this is what it has been mentioned. If my lord will see, that my lord will see 243Q, my lords. There shall be constituted in every state a Nagar Panchayat for a transitional area, that is to say an area in transition from rural area to an urban area. My lords, in fact, if my lord will see the panchayat and the municipality both, there are 3-tier system, my lord, which has been mentioned. It is not that, my lord, one can be upgraded at any point of time without there being any kind of basis to that, my lord. Now, in my condition also, when it has been mentioned that an area in transition from rural area to an urban area, now they have converted it into a urban area, my lords, right from rural area. That is creating a difficulty so far as the petitioner is concerned, because here, my lord, we are in part 4, that is Barota Panchayat. It was a panchayat, and now without, my lord, upgrading it to Nagar Panchayat, at best it could have been done. The second aspect is also that whatever upgradation is done, it is done only on the basis of the population which you have. That is, my lord, which is there. That population is of 2011 census only. Now it could have been considered after 2021. So now that is not there. How can all of a sudden a panchayat is considered only because they had to upgrade this Nagar Panchayat Kasba to Nagar Parishad? I have been taken, and my lords, I have been made part of that Nagar Panchayat Kasba, and it has been upgraded. That is creating difficulty to us. Now the second aspect of the matter is also to the extent, that is annexure 2, if my lord will kindly see. My lord, they had initially notified this, and in view of the fact that 1 month's, my lord, the notice was also given. And here, if my lord will see in column 4, 2 panchayats have been mentioned, my lord. One has been left out, and I have been considered. I filed the objections, and that objection has also not been considered. Because they ought to have considered my objection, they ought to have replied to my objection. Nothing is done, and therefore it is again in complete violation of section 3, 4, 5, 6, 7, 8 of the Municipal Act, my lord. So that is also in the complete violation of the same. Lords, I also have very specific in support of my case, my lord, what I am arguing before my lord, are 2 decisions of this honorable court, my lord. One decision has certainly, my lord, that is, lords, it has been specifically dealt by, my lords, one of the bench.
You belong to which village?
My lords, I am from Bareta Panchayat, my lord.
This Bareta Panchayat,
my lords,
is a village or a panchayat?
Wait.
It's a panchayat.
It's a panchayat, my lord.
It's a panchayat.
My lords.
Now this panchayat,
my lord,
has been included in Nagar Parishad Kasba.
Yes, my lord. What I am saying, my lord, that which I read, my lord would recall right now 243Q, it says very specifically, it has...
According to you,
My lords.
according to you, this Gram Panchayat should have been first upgraded to Nagar Panchayat
My lords.
and then to Nagar Parishad.
Nagar Parishad at all, if it was to be done. Now the second aspect of the
Yes.
The second aspect of the matter is, my lord, that in between the census, my lord, as to what derived them to the extent that it has been included merely because Nagar Panchayat Kasba was to be upgraded for whatever reason, my lord, I have been included into that, and that is creating difficulty because it's a panchayat. There are lots of poors, my lord. I have also filed an IE application whereby, my lord, I have annexed all those objections which is not there on record in the writ application. I have stated that 90% of the people are agriculturals, my lord, very poor, all from the backward category. My lords, I have mentioned all these aspects. These aspects ought to have been also dealt with. And my lord, this has been specifically dealt in one of the decisions, my lord, in order to just, my lord, to cut short the entire issue. But my lords, this matter was certainly set aside.
Please come to your own pleading in paragraph 23 and the statutory provisions under the Municipal Act. Whether you are in a position to satisfy the court that on the basis of this pleading the decision can be said to be invalid.
My lord is probably is mentioning that I have mentioned 75% irrigated land.
Irrigated has nothing, it's a population is the determinative factor.
Yes, the population is the determining factor, and at the same time whether those persons, whether it is agriculture, now there is an amendment in the act. Initially it was 75%,
yes.
Now it is 50%.
So huts, you have mentioned huts, you have mentioned irrigated land.
My lords, there can be, my lords, there may be certain, my lords, in the pleadings so far as that aspect is concerned.
Then
I have mentioned it in the IA application, my lord, my...
IA application is not there.
IA...
And what is the basis?
Sorry,
from
the
where do you derive this data?
My lords?
From where do you derive this data? This percentage and this data or whatever details you are giving?
My lords, it is on the basis of, my lord, the previous census, my lord,
So
which
we
have.
It is not there on record.
My lords, they ought to have, and some personal knowledge also, because we are in that panchayat.
Everything has to be based on
Lords,
the
this
last
will have to
census.
come from the state government, my lord, that whatever, because I have also specifically mentioned one another aspect.
Very difficult because the determination will have to be made on the basis of last census, one,
Right.
and two, population,
My lords.
as mentioned in the act. That is the only basis.
Right, my lord. And there is another aspect also, my lords, which my lord will consider. My lord, this could not have been upgraded, my lords, all of a sudden without, my lords, whatever we are working now is we are working on the basis of 2011 census, my lord. What made the change, my lord? I am conscious of the fact that the collector had the power, my lord, could have notified. I am conscious of those facts. But, my lords, there is no change at the present, and at least my objection could have been replied upon by them had there been any kind of circumstances. Because if my lord will see annexure 2, my lord, there are
Where
two
is
punch.
your objection?
My lords, my objection, I have filed a supplementary, my lords, that must be there. We have served the copy also. We have made 3 objections before the authorities, 4 rather.
It is stated by learned counsel for the petitioner that a supplementary affidavit and an interlocutory application have been filed. First off, the said documents are not there on record. First off, list this matter second week of January along with the supplementary affidavit and the interlocutory application.
Lords, there is no IA application. In fact, by mistake, it was, I had mentioned, it was only supplementary affidavit, my lord. And there is another matter also, my lord, listed at serial number 172, my lord, before my lord, of the similar nature. Both can be
Similar nature, whether same gram
same
panchayat?
same panchayat matter,
Same
my lord.
panchayat.
Yes, my lord. Therefore, both.
Which item?
Serial number 172 in the consolidated list.
Along with CWJC number?
6317 of 2021. CWJC 6317.
CWJC 6317 of 2021.
Obliged, my lord.
23, CWJC number 10054 of 50.
May I pray the Lord put up after vacation?
After?
After vacation.
How is she? What has happened to her?
ये ठंड लग गई है मैडम
हाँ?
को ठंड लग गई है जोर
ठंड
से
लग गई।
बुखार है
All right. As requested on behalf of the petitioner, list this matter on second week of January.
अब लाइए
CWJC number 5576 of 20. Geeta Prasad versus the State of Bihar. For the petitioner, Mr. Ashok Kumar Mishra.
And for the respondent, Jilla Parishad, my lord.
For the state.
In fact, the grievance of the petitioner, my lord, has already been redressed, my lord. She is already in occupation of a shop.
There is no
She herself has
representation on
admitted
behalf
this.
of the petitioner, and counsel for the state of Bihar and Jilla Parishad are present. Most of this application stands dismissed
Lovely.
for default.
25, CWJC number
May I please, Lordship? Lordship, in this case, I have to file rejoinder to the supplementary affidavit, Lordship. Therefore, this matter may be put up after 1 week after vacation,
You are
Lordship.
for the petitioner.
Lordship.
What is this matter about?
The matter is, Lordship, with regard to demand of holding tax, Lordship.
Demand of
Holding tax, Lordship.
holding tax
By the Nagar
Parishad,
person,
Gopalganj.
Lordship. The petitioner is a sugar mill, Lordship.
Petitioner is
Sugar mill, Vishnu Sugar Mill.
as requested on behalf of the petitioner, so as to enable him to consider a supplementary counter affidavit filed on behalf of the respondents. List this matter on third week of January.
Much obliged.
26, 96, 47 of 20, Prabha and Expo, Rashtriya Private Limited versus State of Bihar, for the petitioner, Mr. Suresh.
My lords, I pray for a passover, my lords.
As requested on behalf of the petitioner, list this case tomorrow.
Obliged, my lords.
Along with analogous case. CWJC number 9675 of 20 along with analogous case. For the petitioner, in all the cases, Mr. Sumit Kumar Singh. For the re-election, Mr. Sumit Kumar Singh.
My lord, last date, my lord.
Yes.
Last date, my lord, I am free, my lord. My name is not appear, my lord, in several cases, my lord. Today, my lord, I am several times file appearance slip, my lord. Last date, my lord, or direct to the name is appear, my lord. But my name is not appear in the list, my lord, in several cases.
No, but you are appearing.
My lord, I am appearing on behalf of the BSFC, my lord.
You are present in the court.
My lord.
Have you filed your wakalatnama?
Appearance slip, my lord.
Why appearance slip?
अभी तक तो
You are not state of Bihar.
अभी तक तो जो अपेरेंट स्लिप पे ही नाम
No,
आ जाता
no,
था
अभी तक नहीं. How can you appear without wakalatnama? BSFC is not state government. BSFC is not Union of India. BSFC is a corporation. You will have to file your wakalatnama. Otherwise, you will not entertain. Yes, who is for the petitioner?
There is no representation on behalf of the petitioners. That should be with us tomorrow.
On behalf of the BSFC, my lord, state. On behalf of the
Yes,
all
yes.
cases, my lord.
28. CWJC number 509 of 21, Sarvan Sahni versus the State of Bihar. For the petitioner Mr. Rajesh Kumar. For the state Mr. Anjani Kumar, under age 4.
In compliance of the order dated 23/11, we have filed a counter affidavit sworn in by the Chief Secretary Lordship. Yesterday we have filed copy. We have served yesterday.
What stand have you taken?
Our stand in the counter affidavit that Lordship, the petitioner has concealed several facts, Lordship. Initially, the petitioner was claiming for the payment of wages which he has got, he has received. He has admitted in the writ petition also. Later on, he started claiming the amount of price of the plants, saplings and fertilizers which he has not supplied. One more fact which has been concealed, Lordship, that earlier by the direction of the second appellate authority, an inquiry was conducted by Lokpal Manrega, Darbhanga, Lordship, and a detailed inquiry report we have annexed in the order sheet, Lordship, as annexure B. Yesterday it has been filed, Lordship, perhaps.
It is stated by
My physical copy is with me, Lordship, if maybe perhaps.
That a counter affidavit has been filed on behalf of filed in compliance of this court's order dated 23/11/2021. The said counter affidavit is not there on record. This case January 2nd week.
My Lord, I respectfully submit, my Lord, they have concealed the fact, not answered anything in the counter affidavit. They had issued check for rupees 80,000 yesterday.
It will be open for.
Rejoinder I will file, my Lord.
It is open for the petitioner to file rejoinder to the counter affidavit.
My obliged, my Lord.
29. CWJC number 1074 of 21, Messrs. Frontline NCR Business Solution versus Private Limited versus the State of Bihar. For the petitioner Mr. Madhav Krishna. For the state Mr. Gyan Prakash Ojha.
Your Lordship, I pray for Passover for day, Your Lordship. Requested on behalf of tomorrow.
30. CWJC number 1120 of 21, Sanjay Kumar versus the Chief Manager. For the petitioner Mr. Ravi Bhushan.
Lord, I am appearing on behalf of the bank.
What is your stand?
My Lord, para 9 may kindly be seen, my Lord, page 9, para 19, there is a specific provision that petitioner should file appeal before the DRT under section 13 for Surface Act, 17 of the Surface Act, my Lord. The clear provision.
So in the meanwhile, what are you doing? He has not filed appeal. What are you doing? What the bank has done so far? Auction sold.
Bank wants to recovery of money, my lord, with the huge amount, 26 lakh.
Maybe. Are you going to auction sale the house or the immovable property?
Yes, my lord.
When? Ask your bank not to proceed with any such action. What is the date fixed for auction sale?
My lord, the date was fixed earlier.
There is no representation on behalf of the petitioner. The counsel for the UCO Bank is present. List this matter tomorrow.
31 CWJC number 2124 of 21 Ansila Services Private Limited versus the State of Bihar through the Principal Secretary for the petitioner Mr. Ravindra Kumar.
हाँ ठीक है. My lord, it was heard earlier, my lord, and since I was asked to inquire about the advocate for Masodi Nagar Parishad, he is.
Milords, I am for the Milords and Milords, my counter affidavit is ready, Milords. Just I am Milords, I accessed the Milord, but I did not detail.
So have you paid the amount?
Milords, no Milords.
Then?
Because of the reason, Milords, the Milords, the toilets is till the date neither it has been installed at the door of the Milord, the consumers Milord, not the Milords, it has become operational Milords. Till the date Milords. I have filed the counter Milords.
As requested on behalf of Nagar Parishad Masodi, list this matter on January 3rd week so as to enable him to file counter affidavit.
Yes, I am just Milords, I have filed counter. I am serving the copy of the counter affidavit.
Do that.
ठीक है, कोई बात नहीं.
32 CWJC number 2305 of 21 Messrs. Kumar Tais versus the Bihar Industrial Area Development Authority for the petitioner Mr. Vadehi Raman Prasad Singh.
You can switch your mic on.
Annexure 5 may kindly be seen. Annexure 5 is the surrender policy of Biada. It is at page 28.
Annexure 5 page
28.
कार्यालय आदेश.
My lords, बिहार औद्योगिक क्षेत्र विकास प्राधिकार संशोधन अधिनियम 2017 की खंडिका 5(3) क एवं दिनांक 15/11/2018 को आयोजित बियाडा निदेशक परिषद की 55वीं बैठक के अनुपूरक कार्यावली स्वयं में दिए गए निर्णय के आलोक में अलॉटमेंट सरेंडर फैसिलिटी पॉलिसी को निम्न प्रकार से लागू किया जाता है. जो इकाई स्थापित हो चुकी हैं एवं स्थानांतरण नीति में वर्णित शर्तों के आधार पर स्थापित समझा जाए। यदि वे एग्जिट करना चाहती हैं तो ऐसी स्थिति में वह इकाई बियाडा को विहित प्रपत्र एनेक्सर 1 के माध्यम से सूचित करेगी। बियाडा उसे अपने वेबसाइट पर अपलोड करेगी तथा नए इकाई को वह भूमि आवंटित हो जाने पर नए उद्यमी से प्राप्त राशि में से बियाडा का बकाया एवं 15% हस्तांतरण शुल्क तथा 1% सेवा शुल्क काटकर शेष राशि बियाडा पुरानी उद्यमी को भुगतान कर देगी। पूर्व इकाई पर यदि किसी वित्तीय संस्थान विद्युत कंपनी का बकाया है तो उसका भी देनदार पूर्व इकाई पर ही होगा। ऐसी स्थिति में उद्यमी को भूमि के मूल्य का एक भुगतान करना है। Lord, I had, pursuant to this surrender policy, I had filed surrender application on 24/1/2019, which is an Annexure 6. Without considering that application, my allotment has been cancelled by the order dated 14/2/2019 and Annexure 7. Earlier also my lease was cancelled. I had come in writ, my lord. Then that was decided earlier, my lord. Thereafter, my lord, I filed application for surrender of the land, my lord, and this order has been passed without considering my surrender application.
So your allotment was cancelled?
Earlier cancelled, but that was restored, my lord.
That was restored.
Right.
Then you
Thereafter
applied for surrender.
Right. So my only grievance is that he should have considered my surrender application and then he should have passed order, my lord.
So no decision has been taken so far?
No decision on my surrender policy, my lord. In the meantime, after filing of my surrender petition, the impugned order dated 14/2/2019 has been passed, cancelling the allotment of the petitioner and forfeiture of the money deposited by me.
So when was that order passed? 14/2/2019?
2019 and Annexure 7 at page 30.
Where is your application to avail the surrender policy?
Annexure 6, my lord, at page 29.
Policy here. So have they accepted that you had filed an application for surrender?
Yes, my lord. The seal is there, my lord.
No, the receipt is there, but a counter affidavit has been filed.
They have not closed it.
No, I have stated, Lordship. In response, what my learned senior friend is submitting, Lordship, that has been answered in counter affidavit in paragraph number 26. In paragraph number 26, I have stated, Lordship, that this policy is not covered with this petitioner, Lordship. The land in question was allotted in the year 1996. Earlier, the land was not used by the unit, Lordship. Therefore, the first cancellation was made.
Is this your case that the petitioner's plot is not covered by this policy decision
Lordship, that I have stated in
of
paragraph number
25/11/2018?
Lordship, that I have stated in paragraph number 25, Lordship.
Yes.
Lordship. Paragraph number 26, Lordship, that it is stated that insofar as the averment of the petitioner regarding the allotment surrender facilitation policy is concerned, it is stated that the said policy is not applicable upon the petitioner as he was obligated preliminary to comply with the order dated 14/2017 passed in CWJC number 5449 of 2010. Lordships, earlier cancellation which was challenged, that was disposed of by this honorable court in the light of order passed in division bench, celebrity judgment Lordship Deepak Pent versus Biada versus Deepak Pent Lordship. The order is annexed. The clause C of that very order gives liberty the Biada that if the unit does not perform within 3 months, then the Biada would be at liberty to resume the land in question, Lordships. The unit did not perform. Kindly consider that the land in question was allotted in the year 1996. Physical possession was also given in the year 1996.
No,
but
that
up
is
till
not
now,
the question.
Lordship.
The question is that you came out with a policy in 2018.
Lordship, bare perusal of that policy.
According to you, that policy is not applicable in case of the petitioner.
फर्स्ट लाइन में लिखा हुआ है सर कि वो स्थापित यूनिट के लिए है. हिज यूनिट वाज नेवर स्थापित. ही डिडंट परफॉर्म. Up till now he has not performed any job on the land in question. कभी रेंट लगा दिए, कभी कुछ कर दिए. इस तरह का इनका है.
And what is this? स्थानांतरण नीति में वर्णित शर्तों के आधार पर स्थापित समझा जाए.
जो यूनिट स्थापित है, अगर वो काम नहीं करके किसी को स्थानांतरित करना चाह रहे हैं, दूसरे को देना चाह रहे हैं, that is for that. उनका यूनिट एस्टेब्लिश्ड है और अब वो दूसरे को सरेंडर कर रहे हैं, ट्रांसफर कर रहे हैं.
No, Mr. Counsel, please come to annexure 5 again, this 25, the order. It says, दो इकाई स्थापित हो चुकी है, 1, एवं स्थानांतरण नीति में वर्णित शर्तों के आधार पर स्थापित समझा जाए. स्थानांतरण नीति में वर्णित शर्तों के आधार पर. Is there any?
And moreover, Lordship, this policy came in the year 2018 and he was obligated to comply the order passed in terms of division bench.
Paragraph 9 of my petition may can be seen. The unit had started manufacturing.
That we have seen.
Paragraph 9.
Yes, yes.
No document in support of that pleading is there.
That is quite vague statement. Started manufacturing, and at the same time the land was not developed by Biada.
Yes, that was the reason.
So he is right, the Biada is correct that this policy is applicable only to such plots where the units were established already.
It was established as I have stated in paragraph 9 of my petition, my lord.
Statement will not do.
I will file supplementary affidavit.
Supplementary affidavit? What supplementary affidavit?
हमने क्या काम किया था, नहीं किया था उसका. Time may be given, I will file supplementary affidavit.
Where is the order on the earlier writ petition?
of the order passed will be in Annexure 3.
Annexure 4.
And you have forum before the appellate authority. You could have gone there. Otherwise, you have a very don't have a case.
हुजूर उसके लिए भी 30 दिन का ही इनको समय रहता है। ये देखा जाएगा कि कैंसिलेशन ऑर्डर कब का है। ये हाई कोर्ट में आके कंडोनेशन डिले कंडोन कराने के लिए इस तरह का पिटीशन दे रहा है। 1996 से लैंड को रखे हुए हैं।
You can reject on the very date when he files the bill.
Permitted to file appeal. Permitted to file appeal.
That you may do. We are not saying anything. When counsel for the petitioner after some argument seeks permission to withdraw this writ application with a liberty to prefer appeal before the competent authority in the light of the preliminary objection taken on behalf of the respondent Biada in its counter affidavit. Stop. This application stands dismissed as withdrawn with the liberty as sought.
33 CWJC number 2309 of 21 Shyama Buildcon Private Limited versus the State of Bihar. For the petitioner Mr. Sushil Kumar Singh. For the state Mr. Anjani Kumar, learned AG 4.
Application has been prepared for direction upon the respondent to make payment and execute this due lordship 45.24 lakh due lordship on account of work executed in the minor works department due lordship. Petitioner is the registered contractor due lordship and he has been granted a construction work like the minor irrigation, minor water resource department.
When had you executed the work?
Your lordship.
When had you executed the work?
Your lordship, work has been allotted in the year 2011, your lordship. Thereafter, I have...
When had you completed?
Your lordship, may kindly see page 18, your lordship, annex 3. Pursuant to your furnishing, the requisite security as stipulated in ITB, clause 3.4.1, and signing of the contract for construction of the so-and-so, extensive renovation of Amartha, Itaria, Majharia, Ahar Pine scheme, bid price so-and-so, rupees so-and-so, you are hereby instructed to proceed with execution of said work.
When did you become entitled to receive the money?
Your lordship.
When did you complete your work?
Your lordship, that work has not been completed in the year subsequent stage, your lordship, when the 55% or 58% work has been completed, reorganization between the department has been taken for your lordship, and under that scheme, your lordship, that work has been transferred to another division, your lordship. Thereafter, your lordship, work has been stopped and the bill has been finalized, Your Lordship. Your Lordship may kindly see at
Your
page
bill is
19,
pending
Your
since
Lordship.
when?
Page 19, Your Lordship, may kindly see.
Page?
Page 19.
19.
Your Lordship.
Your bill is
Annex
pending.
4.
Your bill is pending since when?
My bill is pending, Your Lordship. That is the page, Your Lordship. 24. 5/2/2016, Your Lordship. Thereafter, Your Lordship, the respondent authority has sought a location for making the payment of that bill, Your Lordship.
You have been paid no money. No amount has been paid.
No, Lordship, about 1.79 crores has been paid as per the government.
This is the residual part, Your Lordship. That is a still due, Your Lordship.
And it appears from the...
Even after the recommendation has been made by the higher authority, Mukhya Abhiyanta and so, Your Lordship, that amount is still pending.
Where is the recommendation?
Your Lordship. Your Lordship, may kindly see page 25, Your Lordship.
That is not for you.
Yes, Your Lordship, that is the inter-authority correspondence, Your Lordship.
That is not in respect of your work. स्वीकृत योजनाओं के अंतर्गत
अमरता इटड़िया मजरिया आहार पहल योजना के लिए कार्यों का भुगतान अधियाचना के संबंध में।
अब किस कार्य में आपका 11-12 का था, ये 15-16 का यहाँ बात हो रहा है। We don't know which
बिल ऑलरेडी मेरा बिल ही प्रिपेयर हुआ 2016 में, देखा जाएगा लास्ट पेज पे जो है 24 पे, उसमें डेट देखा जाएगा 5/2/2016 को कृष्णा कुमार सिंह को ये बिल ऑलरेडी उनको माफी हुआ है।
File your affidavit.
Some time may be granted, counter affidavit is to be filed. It is required, Lordship.
4 weeks time is allowed for the state of Bihar to file counter affidavit. Let this case 4 weeks.
Obliged.
By the time case number 16 was going on, no one appear had been mentioned or possible appearance.
Where? All right.
Item number 14, Lord.
All right.
So I am praying Lord, serial number 24, Lord. I have been asked to
After vacation, for listing after vacation, because rejoinder is required to be filed in serial number.
Let it, whether the matter was called.
My lord, this has been called, my lord.
कितना?
24.
24 तो dismiss हो गया.